Lord, may I have your lordship's kind leave to mention, my lord, for enlistment of the assigned matter, my lord.
Yes.
My lord, may I
The gift deed has not been made a party, no notice, no proper proceeding. It was a proceeding under section 4 and 5 of the 2007 Act, Senior Citizens. But Lordship, they invoked the section 23 and cancelled the deed and directed to Lordship evict this Lordship the beneficiaries within a period of 15 days.
When did the senior citizen expire?
2020 in the during COVID.
All right.
Now the the donee expired in 2020. Senior citizen donor is alive. Donor filed an application under section 4 and 5 of the maintenance.
Yes.
Subdivisional officer invoked section 23 and Lordship cancelled the deed. And all the beneficiaries are not the parties, no proper notice. Now, Lordship,
what is there to take leave? You file it in the department.
No, Lordship, I am praying for today because, Lordship, the 15 days they have directed the concern. IC also has been directed to remove these petitioners from their this property.
Today, no leave. You file it in the department, it will appear in the list.
Yeah, Lordship, kindly tomorrow, Lordship, at least. Otherwise, Lordship, if I evicted, Lordship, then it will be some difficulty, Lordship.
The state government is under a holiday today and tomorrow. So who's going to go and evict you? The police.
Lordship, the IC has been directed. That is the order, Lordship, have come with
when
the
is
order.
the matter returnable before the
already disposed of?
Disposed of matter.
Yes.
It will appear in the list Friday.
Friday, Lordship.
Thursday is a holiday. You serve notice because notice is required to be served.
So in the meantime, may I communicate the
happen.
matter is pending not to take any adverse steps? Lordship, kindly grant me leave, Lordship.
No. You file it in the department, give the number. Friday it will appear. Yes.
I just to mention for a leave, extremely urgent matter, my lord. I was a running scanning contractor with the railways. I've been terminated by an authority who's not entrusted with the power to do so. I'm carrying your lordship's order on similar occasion. Lordship has set aside that order of termination. Now, in furtherance to that, they have floated a tender which is going to open on 30th of this month. That is on Thursday. And Thursday being a holiday, my lord, I am beseeching your lordship to take it up on Wednesday, my lord. I will serve.
Sir.
may I be permitted to mention, my lord, for inclusion? My lord, for inclusion, the application.
Yes.
My lord, on Friday, your lordship on monthly list item number 296 matter was dismissed for default. My lord, I was running from bar association, but your lord
Dismissed for default. All orders have been signed. It will be put up in the server soon.
it's not yet being served. Just now I have checked.
No, may not be, but then I have signed the file and the file is not with me.
Yes,
it has been sent.
Your lordship.
I am praying. Enlistment? Enlistment? Yes.
Need to travel. There's an urgent application. He needs to travel on 2nd. The passports are deposited with the lower courts. There's matters pending before your lordship. Liberties were granted to exchange affidavits and thereafter come back before your lordship. The state respondents have not taken any steps since February.
State is the passport authority should be the answering respondent.
All the parties of your lordship are directed to file their respective oppositions.
Nobody has.
February, nobody has. In the meantime, there's an engagement. He is supposed to leave on 2nd. He has got the permissions from the governments, all parties.
Which government has given you permission?
The Jharkhand government has given me permission to travel to for the meeting in London.
Yes.
And your lordship had directed.
How is Jharkhand coming in over here?
He's in the ministry of Jharkhand government. He is traveling from Jharkhand. He's supposed to only litigation is pending here in Calcutta. His passports are deposited. Your lordship was hearing the matter. In the midst of it, since this urgency has come up, your lordship will grant us leave only to move this application urgently, and thereafter your lordship will decide with the repetition as and when your lordship feels convenient. If possible, Wednesday at 3:30, 4 o'clock, whatever time is convenient, your lordship. We'll notify the other sides.
Wednesday.
Wednesday.
Your Lordship,
I am praying leave, my lord. Jana Babu.
Your Lordship, I'm praying
That I am
for
praying leave, my lord, before your lordship, my lord. The respondent number 12, my lord, constructing a house, my lord, that is will be used as a party office of the present ruling party, my lord. Already 17(1)(b) notice has been issued by the district magistrate in the month of September. Already, my lord, 4C notice, 4D notice has been issued. In spite of that, my lord, 3+1, that is 4-storied building of the present ruling party office, my lord, has been constructed, my lord, by filling up the pond, and that is, my lord, pond used more than 200 years for the use of pisciculture. My lord, already, my lord, order has been passed by the district magistrate, ignoring all the provision of the acts and rules. My lord, the construction has been going on. What order? Time. What order did the DM pass? My lord, DM, my lord, restored in its own position. My lord, order has been communicated to you, and 4D already issued. My lord, ignoring all the facts, my lord, the respondent number 12 is the present secretary of the present ruling parties. My lord, any date as your lordship convenience, I serve. File it Monday. It will appear. Monday.
My lord, may I be permitted to mention one matter, my lord? In this matter, my interim order is expiring tomorrow, and the matter was directed to be listed today. However, the matter is not listed. I'm humbly praying if the matter can be kept tomorrow, my lord, for extension.
My lord, I'm
Serve notice, extension of interim order.
my lord, I'm
This is not an inclusion in the list as new motions.
When did you file it?
Vacation bench
Vacation bench matter.
to the
Whether it will appear in the combined list. Give the number.
my lord,
Combined list.
with notice to
I'm
the
mentioning for inclusion of the matter. Section 14 application have been filed before the district.
What is the stage of the matter?
The matter, the auction, the property.
Stage. Has it been filed?
Section.
When?
No, I'm just mentioning for inclusion of the.
Where is the file? You don't know?
No, this is not in the list, my lord.
Where is it? When did you file it?
Department.
When?
Last week, Friday.
Last week? It will appear in the combined list. Don't worry.
Your Lordship,
My lord, may I be permitted to mention item number 170 for upgraded motion? My lord, despite clear and recent order passed by SDO Tamluk of that the private respondent does not belong to OBC caste category, that private respondent certificate is still holding, and she is
You want cancellation of the caste certificate?
Yes, my lord, and
It's there in the
it has
list?
not been revoked.
Right. It is there in the list.
There in the list.
Let it remain. Yes.
Your Lordship's leave, my lord. This pertains to a tender matter whereby I have been outcome as a for L1 bidder, my lord. However, there is a technical glitch on my header because I have put an additional zero. The base price of the amount of the in respect of the tender was 17 lakhs.
Do you understand what that additional zero means?
My lord, what has happened, my lord? I must be candid, my lord. I have immediately informed them what they have done. They have cancelled the tender. They have forfeited my money. 23 lakhs or around is pending with the Port Trust Authority, my lord. There is a, I'll satisfy your lordship because.
No, don't satisfy.
My lord,
Satisfy your client
my lord,
first.
I kindly appreciate.
No.
It's a e-tender process, my lord. When
Yes.
the e-tender process indicates that if there
The
is
matter has been filed.
a matter has been filed, it was running in the month list. I tried to mention your lordship before the vacation, my lord. How your lordship was pleased to direct me
Right.
to come after vacation, my lord. I'm seeking.
Still wait.
I'm seeking out.
Your Lordship, I'm mentioning for a leave, Lordship, where I am the owner of a vehicle, goods vehicle that
What
has
you want?
for Lordship for filing this matter because my
Go
vehicle,
and file it. Who's stopping you from filing a writ
Lordship,
petition?
my vehicle has been stopped with them.
Go and file it.
Lordship, I wanted an urgent basis. I have notified them a lot of times. From 14th October, I am notifying the ADM, but the ADM is not taking any steps.
Yes.
For that reason, Lordship, I
Right.
am
You
just
file it in the department and then mention. Yes.
I'm mentioning an urgent motion for upgradation, my lord. My lord, 84-year-old widow, my lord. She is not getting the pension because the pension disbursing authority is not forwarding the documents to the ministry, my lord.
Where did she work?
My lord,
Where did
my
she
lord, with the
work?
freedom fighters pension case, my lord. His
Freedom
husband,
fighters
my lord,
pension.
the law says that the pension disbursing authority is to forward the documents of the widow to the ministry, but they are not doing it, my lord.
Yeah.
And she's not receiving her pension, my lord.
Where is the matter?
Well, it's running as item number 1229 of the monthly list, my lord, of September, my lord. Kindly keeps it any day, my lord. She is 84 years old, my lord. Very sick, my lord. But unnecessary, this is being delayed by the pension disbursing authority, my lord.
You mention when the new list will be published in November. You please mention.
My lord.
All right.
Can it be kept this week? My lord?
Don't raise your hand.
No,
Not you, not you. Somebody behind you. I'm not.
Your Lordship, may I have your kind leave to mention item number 215 of your Lordship's daily list today. Your Lordship, praying for upgradation in the matter. I'm facing contempt proceedings in the matter in a coordinate bench, Your Lordship. And I have filed a separate writ petition against NHAI because I am facing contempt proceedings because of their non-cooperation. They are not providing me with a letter which is required to build a petrol pump, Your Lordship. That's why I'm facing the contempt proceedings from like in another
So
coordinate
you
bench.
take up the contempt matter. Let the court take up. You and seek direction from there.
Your Lordship, they are not allowing me to implead NHI at this stage, Your Lordship. That's why I have
The
filed.
court is there. Who is the other side to stop you? The court must be there. You say whatever your submission. The court will consider it. The matter is there in the list. It will be taken up. Yes.
To mention one matter for upgradation, my lord, item number 86 of today's list. My lord, the petitioner is exposed to substantial risk due to his being a partner of the firm. He has to carry voluminous cash. So he has applied for arms license for the district magistrate, my lord, and the same is not being considered by the concerned authority.
Let it remain. I'm not upgrading. Yes.
But I permitted to mention for inclusion in the list, my lord.
Under the heading.
My lord, one new motion and another, my lord, application.
When was it filed?
My lord, new motion has been filed in the month of July.
It has not been listed, or it is there in the list.
No, my lord. Never, my lord, listed, my lord.
But then all new matters are listed.
No, my lord. I am not, my lord, find any my application, my lord, from monthly list and my lord. September monthly list, there have no, my lord, matter in my.
No, September month. You said you filed it in July.
Right. August, there have no, my lord, means thereafter, my lord, September, there have no.
জানাবো জুলাই মাসে ফাইল হয়েছে আমাদের লিস্ট হয়নি give the number it should be there this should not happen yes
Another, my lord, application, my lord, on, my lord, 22nd September, my lord,
prior to the vacation that is all right application is all right but then the new motion you give the number it will be checked up yes please
My lord, I am the borrower mentioning upon notice to the bank. My lord, on Friday, on the reopening day, the bank has obtained an order for my eviction under SARFAESI Act from your lordship, suppressing the fact that, my lord, the DRT has stayed the eviction proceedings. The DRT has passed an order staying, my lord, the proceedings, my lord, before the magistrate under section 14, suppressing that, my lord. Unfortunately, my lord, we could not remain present, my lord, because, my lord, there was some difficulty with the board. My lord, the bank has suppressed this fact of stay, my lord, and has obtained an order from my lordship, my lord, for expeditious, my lord, eviction of me. And, my lord, almost entire principal amount paid and DRT given stay.
My lord, I am appearing on behalf of the petitioner bank, my lord. My lord, this writ petition was filed in the month of July. They obtained the order in September. I was about to mention it, my lord. On Friday, they gave me a call that this was when the moment I communicated the order, my lord, the bank said that they have obtained a stay, my lord.
So it was not within your knowledge when the matter
was not within my knowledge, my lord. I actually, my lord, wanted to mention this matter and want withdrawal of that.
very well to be mentioned
To be mentioned, my lord.
give the number
236, my lord, of the monthly list.
give
They obtained the order in the month of
236
September.
236 of the monthly list to be mentioned on
Not been uploaded yet.
all right Friday day after tomorrow
I'm so grateful, my lord.
So, my lord, for non-prosecution. For non-prosecution, my lord.
My lord, may I have your lordship's leave to mention a vacation bench matter, my lord. On the last day, my lord, I had obtained a leave from your lordship for an urgent listing, my lord. Your lordship had heard the matter. It was regarding a vehicle which was blocked without assigning any reasons, my lord. Now, my lord was pleased to post it before the vacation bench, my lord. The vacation bench was pleased to take up the matter. Still, they were given the opportunity to let me know the cause. I have visited the district magistrate. Even I have mailed the concerned ADM that kindly let me know what are the reasons of blocking my vehicle. My client has already visited you. They didn't let me know, and my vehicle is still blocked, my lord. If the matter can be urgently listed before your lordship, my lord.
it is not there in the list
No,
now
my lord. It was in the vacation bench,
give the number
my lord.
With the lordship,
My lord, when it my lord.
Friday
Right.
give the number
with the lordship sanction, I'm mentioning this urgent motion, my lord. The petitioners are participated in 2 tenders floated by the
where is the matter
the matter was filed on 16th of this month before the honorable vacation bench. The files are lying in the department, my lord. The matter was extremely urgent. Her ladyship, the Honorable Justice Smita Das, they
had granted us leave to move the matter on the same day on 16. The matter was included in the supplementary list, but unfortunately, due to paucity of time, the matter could not be taken up. My lord, my read petition will become infructuous because on any day the work order may be issued by the respondents concerned.
So from 16th till the 27th, nothing has happened.
Nothing has happened, but my lord, we are apprehending that the respondents concerned may issue the work order in any day.
Yes.
They have filed the read petition.
You are an unsuccessful participant in the tender.
Successful bidder. I was selected as an eligible candidate also.
Yes, then what happened? Why will work order be issued in favor of somebody else?
My lord, I'll satisfy your lordship. We participated in 2 tender processes. So, in respect of the second tender process, already work order has been issued disregarding all the tender norms and the requirements that are there under the law. In respect of the first tender process, we are apprehending that the respondents concerned are moving towards the same recourse.
Yes.
So, my lord, any day the work order may
Who is the respondent authority?
Indian Railways.
The railways. Right.
But it is extremely urgent. My read petition will become infructuous if it is not heard promptly.
Next Tuesday it will appear.
Next Tuesday.
Not tomorrow. Tuesday week. Give the number and notify it to the. If you know the council, it is all right. If not, then 11 Strand Road. Serve notice.
On 16th November 2020, passed an order.
No, you do not have to give the history, give the number.
Lordship, may I permit to mention for inclusion a update matters?
Inclusion?
For a matter in stage of updated matters.
Inclusion is different, upgradation is different.
Lordship, in the stage.
Yes.
Lordship, item number 325 of the monthly list, Lordship, which has transferred from the Jalpaiguri Circuit Bench, did not till now I did not serve the notice to the state. On Friday, Lordship, it has called, but it has dismissed for default due to at that time I was absent, Lordship. So Lordship, I was just praying for recall.
It cannot be done. It has been signed and everything is done.
Let's kindly to mention item number 176 of my lord's daily list. I'm praying for upgradation of this new motion. Very small issue where the petitioners are flat buyers who have purchased flats, paid the entire consideration in respect of a housing project of a state authority. Now, some internal dispute between the developer and the housing project, my flats are not being registered. So that is the sole issue. Nothing. The entire consideration has been paid. So registration has been stopped by the authority for some internal dispute which none of us have been communicated with. So despite having paid the entire consideration, our flats are not being registered.
So why don't you go before the tribunal and everything is there? Why before?
It is the state authority who is doing it. But the issue is very small. There's really nothing involved. There's no infraction on our part. Nothing is there. The entire consideration.
Somebody must be standing in the way. Your developer in every.
We do not know. There must be some issues.
Obviously.
We have not been communicated with anything.
May not be communicated.
Whenever we are going for registration, they are saying no, registration cannot happen. Nothing else communicated.
Your problem lies somewhere else and you want to invoke the jurisdiction of the writ court to get a shortcut way to get things done. Yes. Right. So you should hold your seller for not registering, getting the property registered.
We have issued letters to them.
Yes.
That the authority is not.
Let the matter remain in the list. I'm not touching. Yes.
This would not hardly take any time. If your lordship kindly permits for it.
Mention when the monthly list is published, then let us see. Yes, it will be put up in the monthly list. Serve the learned advocate representing the state respondents, because the very first day possibly consideration order, nothing more than that can be given. Yes. So get hold of your learned friend. Let us see. Come. Give. Give. Yes.
Wait, please, Your Ladyship. It is the same matter where Your Ladyship was pleased to direct the defense to file their reply by 25th of September. They've again not filed it, and which is why I'm mentioning this matter upon notice. If Your Ladyship be pleased to keep it under the heading mentioning, to be mentioned, and direct them a specific timeline. This was Your Ladyship's order that they were directed for the second time on 25th of September.
Give.
And Your Ladyship...
Friday it will appear? Appellate side matter?
Appellate side matter.
Friday it will appear to be mentioned. Serve notice.
I will. Your Ladyship, I did not get an opportunity before. May I convey my regards for Shubha Vijaya?
Shubha
Much
Vijaya.
obliged.
Yes.
And just to mention that item number 131 of the monthly list of September, but what has happened for the National Commission for Eviction has passed an eviction order against me. Now, sir, the police has verbally intimated them that the commission has asked for police services for eviction, but first is the test date for eviction, 1st of November.
And the National Commission has directed the police to provide assistance. Friday it will appear. Serve notice. Yes, please.
Madam, may I be permitted to mention item number 96 of today's list before your lordship? The petitioner is a learned advocate before the Hon'BLE subdivisional court, and my lord, after being recommended and by the interview board, and my lord, upon payment of the prescribed fees for the purpose of issuance of the certificate of practice as a NOPAT, my lord, the state government remained silent.
Yes. But the petitioner is practicing as advocate.
Yes, my lord.
Then
And
why?
And my lord, he appeared in the my lord before the interview board, my lord, to act as a notary. My lord.
Yes.
And my lord, she has paid the entire amount.
It doesn't matter. Let the matter remain in the list. Yes.
My lord, I am the writ petitioner. My lord, I am led by Mr. Sudhoshatto Banerjee. But my lord, may I just attempt, my lord, at moving the matter?
Who is your other side?
My lord, the railways, my lord. They've been appearing in the matter, my lord. It's been coming up. It's come up for the third time today.
Yes.
My lord, GA1, my lord, is an application.
Is a resolution of the Bar Association not to take up matters in the absence of the other side? Is there a resolution? If prayed, and if the other side is not there, there is no prayer for adjournment. So ex parte matters can be taken up.
Lordship, may I beg to appear on behalf of the respondents through virtual mode, Lordship?
Oh, yes.
We have not yet received any instruction. I am seeking for a week time, Lordship, for a
Yeah.
written instruction.
How soon are you expected to receive your instruction? And this was on 16th of September.
1 week, Lordship.
1 week.
Only 1 week, Lord.
Please come. At the now on the request of the learned advocate representing the respondent railways to come ready with proper instruction in the matter, released on 10th of November.
10th of November. Lordship,
Written instruction shall be obtained prior to the adjourned date.
My lord, in response to GA1, if your lordship may be pleased to clarify.
All right. In connection with the application. Yes.
Grateful, my lord.
My lord, I am for the respondent number 5.
My lord.
My lord, I am for the respondent number 2, 3, and 4. My lord, I have a point for maintainability, my lord.
You have a?
point of maintaining.
All right. Respondent number 1, is anybody appearing?
Lordship, no, the respondent number 1, the RBI is not appearing, my lord. RBI is, my main prayers are directed towards RBI only, my lord.
So why are they not
This-
appearing? Did you serve?
This matter, yes, my lord. This matter was taken up the last day before vacation, my lord. There was a leave granted to move the matter before the vacation bench, my lord. The matter was moved before the vacation bench as well, my lord, and then it's appearing today. But none of the days the RBI appeared, my lord, despite notice.
দুটো আছে হ্যাঁ আচ্ছা
You were given leave to file a supplementary affidavit.
Yes, lordship. I will need another week's time, my lord, to file that because the
All right,
vacation.
please come. Learned advocate for the petitioner seeks extension of time for filing the supplementary affidavit. Step none represents the Reserve Bank of India. Step a point of maintainability has been raised by the learned advocate representing the respondent numbers 2, 3, and 4.
and also my lord I am respondent number 5. I am also on the maintenance
4 and 5.
because it's a
2, 3, 4, and 5.
private respondent and ICICI Bank being the private opposite party.
Acha. Let notice be served upon the non-appearing respondent. Let supplementary affidavit be prepared and circulated by 7th November. Released on 17th of November.
Grateful, man.
Yes.
Grateful, man.
My lord, I beg to appeal for the petitioner, my lord. My lord, the petitioner number 1 is a company and petitioner number 2 is the director of the company. My lord, petition has applied.
Who is the other side?
The state respondent we have served, my lord. They are received on 8th October. My lord. This is the updated affidavit service, my lord. My lord, we have applied for a homestay registration, my lord, on 27th of March 2024. My lord, thereafter several order has been passed, my lord, several persuasion has been done, no steps has been taken. On 11th March, my lord, the nodal officer, my lord, has issued a notice for submitting certain particulars, my lord. We have submitted those particulars on 25th of March 2025, my lord. Thereafter, my lord, till date, no steps has been taken. We have made several communications, my lord. Nothing has been done, my lord, by the department, my lord.
Where is your last representation?
My lord, the last representation. My lord, I'm late by Mr. Sen, my lord. Sir,
But one difficulty which is arising here, but I have applied online for this registration of this homestay. But there is a provision for uploading a demand draft. I have prepared a demand draft. There is they are not taking the demand draft. Then when I have made an inquiry,
Taking means that it had to be uploaded, isn't it?
but it is the site, the portal
Not
is
accepting.
not accepting. Then my lord, I made an inquiry with them.
Yes.
Then kindly see this document. চিঠিটা বার করো যেটা দিয়েছিল। Just kindly give me 1 minute. ওরা যেটা দিল নোডাল অফিসার। Kindly come to page 38, my lord.
Yes, 11th of March 2025. They had
They have
requested
also
you.
asked me to furnish the information. My lord, I have furnished the information on the next page.
Yes.
Now thereafter, my lord, I have asked for an also from the Information Act whether any trade license or anything is required. They are saying there is no trade license required. Earlier, what happened? I was carrying on the business of paying guests from these premises. They revoked my trade license. They filed a writ petition saying that I am carrying on business. I am saying I have said before the writ court that I have applied for homestay registration. I am not carrying on this business. So, my lord, my paying guest business is stopped. I have applied under their policy for an online registration of homestay. There is no response to this. I am ready and willing to deposit the money. Well, let them come out with a proper.
Where is this provision for uploading the demand draft or
So
something?
that is in the online application itself. The online application is at page 16. And in the policy also, my lord, the West Bengal homestay tourism policy, which I have at page 20, your lordship will see. Clause 5 of
Are you aware as to who is your other side?
My lord, I have served on the nodal officer also, who has given me that communication for furnishing of information.
Is the AOR's office served?
State of West Bengal. I have actually served directly upon the respondent.
AOR should be served.
Very well, I will give once again.
দিয়েছে notice দেখুন তো।
AOR no, my lord, I have served actually the direct.
Then nobody is going to appear if you serve
That
them.
is the difficulty.
None represents the respondents. Stop. Let a notice be served in the office of the learned advocate on record for the state of West Bengal. Stop. Release the matter for further consideration on 4th November 2025. Learned advocate representing the state respondents shall come ready with proper instruction with regard to the fate of the petitioner's application for obtaining license for running homestay business. Affidavit of service taken on record. No. Nothing.
No hearing, Lord.
No hearing, nobody will be interested now.
Lordship, my other side is there, Lordship.
Your other side is here. What was the matter?
Lordship, that is the registration of deed, Lordship, that was pending for 17 years.
দেখি পরেরটা দেখি। One minute. Any
The file our report, my lord.
Yes.
It was presented in 2007 a 8 kata 7 chatak plan at Rishi Road. Presented as set for value of 36 lakhs. Registering officer did not register it because it was undervalued. Rishi Road was surrounded on 3 sides by roads. 8 kata land. It was not registered, but not the second step is not first minute he will have to have a doubt that it is not the proper value. Then he'll have to make calculation and intimate. That was not done. So they say they also did not approach us from 2007 till 2024. It was not.
Now what is the way out?
Now it can be, we can value it on the date of presentation. That is what we have done in 2024 November. We have valued it at 2 crore 96 lakhs and odd. The valuation of 2007. They say no, now you have to register it at the set for value only. You have lost your right to invoke 47A. That is their case. Because of the delay on your part, you have forfeited your right under 47A. We say that you have also not approached us. We have also not done that part.
So this is to be heard. This cannot be done.
Lordship, of course. Lordship, I am not supposed to approach them. As per statute, they have to calculate, they have to intimate, and there is a time bar within 4 years, Lordship. And Supreme Court judgment says that is the mandatory. That is mandatory. So they are out of.
I'll hear. No, nothing. Let it remain as it is. I'll hear it.
Lordship. Remain in the same position, Lordship.
Same position.
My lord, item number 6 of the original side, my lord, the talks of settlements are on between the parties. We are only requesting for an adjournment, my lord.
Item 6.
Item 6.
Yes, Lordship. I appear for the respondent.
At least one line order.
It is there in the list. Item number 6. Learned advocate. Who are you representing?
Petitioner, my lord.
Learned advocate representing the petitioner submits upon instruction that talks of settlement are going on in between the parties. Stop. Prayer has been made to adjourn the matter for the time being. Stop. Achha. In view of such submission, release the matter for further consideration on 2nd of December.
Lordship, one thing not in the matter, Lordship. The resolution is also speaks that if other side is absent, then adjournment should be given leniently. What is different?
Grateful, your lord.
Yes.
I pay for the petitioner, your lordship.
Why to be mentioned?
My lord, on the date when it was mentioned by my junior, my lord, it fell from my lord that it may come under group 5, my lord, but I am not sure, my lord, because it's against the primary respondents of the health and family welfare department. So I am also not sure whether it would come under group 5 or not, my lord. The dispute is with regard to appointment of Asa Karmi, my lord.
Asha?
Yes, ma'am.
Then it should go before the group 5 bench possibly?
I'm not sure.
You are not sure?
About whether it under my how for my understanding
Prayer,
it would come under
what
group
is
9, my lord.
prayer is for appointment of Asha, you say?
Yes, my lord, to reinstate the petitioner, my lord, who was initially given appointment. However, on some ground that she is not a resident of the subcenter area for which it was, on that ground, it has been cancelled and appointment is given to the private respondent, which is wholly incorrect. My client is the permanent resident of that subcenter area only, my lord.
Who are you representing?
But I am appearing for respondent number 5, my lord, the private respondent.
Please come.
My lord, I have
The
come.
matter relates to appointment of Asha. Which place? Where is it?
Raghunathpur district, Hooghly, my lord. It's
In the district of Hooghly. Stuff.
the appointment was
The matters relating to appointment of Asha is are heard under group 5. Stop. Let the matter be released from the list of this bench and be placed before the group 5 bench. Bench taking up group 5 matters.
My lord, I appear for the respondent of 2 to 5 KMDA. This matter, my lord, today I find that is for explanation of interim order it is appearing. This matter was moved during the vacation. My lord, I oppose this prayer. The writ petition is not only hit by the principles of res judicata, but also the petitioner has suppressed the material fact. If I am permitted to say so, my lord, the petitioner has practiced fraud with the court to obtain.
You are representing KMTA.
KMD.
KMDA was not present.
KMD was not present.
Although served, my lord, the affidavit of service is already there. His lordship, my lord, upon being satisfied with service, my lord, had taken up the matter.
But
all right,
perhaps their office was closed, my lord. It was only on the day of Dadoshi, my lord.
We have received it on 8th. That is why, my lord, it was not possible. Dear lordship,
that is the
petitioner has challenged the order passed by KMD authority directing the petitioner to vacate stall number 16,
issue.
which petitioner is in possession for a long period of time. Show me the order of vacation.
Page 41.
Order. Vacation.
No, not the bench, the vacation.
Page 41.
Eviction. Will vacate the stall as per the decision of the competent authority is notified. Occupiers fish stall. All right.
Now, first of all, my lord, by order of KMDA.
Before my learned friend proceeds on merit, my lord, I have a preliminary issue. My lord, lordship, bear me for a few minutes.
Issue, what is the maintainability issue?
Maintainability. This writ petition itself is not maintainable. Because the alleged claim of the petitioner has long been decided in 2017.
All right. You raised the issue. I have followed it. Let him place. I'll give you an opportunity.
Yes.
2017, 2017, page 28 is the order.
Yes. Lordship, kindly have a look this order.
All
this
right.
order will. So for my.
And this order was passed pursuant to some order passed by the court.
Yes. That was that order, my lord, is at, my lord,
page 31.
25.
25. Yes.
Now, kindly see, my lord, this order, page 25.
Let him make submission then.
Consider and decide the representation. There was a direction for consideration and
Representation.
consider
Now,
the
my lord, this
representation.
representation, my lord, was taken up. Now, my lord, lordship would kind enough to come to page 28. The relevant portion, my lord, is I am not placing it in entirety. Kindly comes to page 29.
Yes.
Kindly see the last paragraph of page 29.
Yes.
Thus, it is evident from the facts above facts that the petitioner has been have never been allotted stall number 16 by Howrah Improvement Trust and Kolkata Metropolitan Development Authority. The petitioner, instead of illegally occupying the stall number 16 for a considerable period of time, and this cannot be considered on the basis of for conferring any right to the petitioner to claim the regularization of occupancy of the stall by way of any allotment. Hence, I am of the considered opinion that the prayer for petitioner is not sustainable and is hereby rejected. Therefore, my lord, it was rejected. Now, my lord, challenging this, my lord, we came up, my lord, again before this Honorable Court at page 31.
Yes.
The order starts, my lord, from page 35.
Yes.
If your lordship would kind enough to come to, my lord, the operating part of the order, page 38.
Yes.
Kindly see, ultimately, my lord, the writ petition was dismissed. It was not interfered with. Now, my lord,
that means the order of KMDA was upheld.
Right.
Now you.
Now, my lord, we were in possession. My lord,
How could you be in possession despite the authority coming to a finding that you are under illegal occupation?
Exactly, that is my point, my lord. Here, my lord, the order of the KMDA says I have no right.
Right.
Kindly, my lord, sees the order again and again.
Yes.
It says I don't have. There was no order for eviction. It says I do not have any right. I may be a trespasser. My lord, law is, my lord, even a trespasser has to be evicted without a without following the due process. That was never done. Kindly see, my lord, on 19th May, my lord, at page 41, my lord, this notice was issued to vacate within 7 days by order KMDA. Who in KMDA? My lord, we do not know. This was, my lord, on 19th May, my lord, notice was given to us on the very last day of the before the, my lord, the Durga Puja vacation, on the very last day, after
This
5
May
months.
notice was served in September.
September, yes, before last day. We did not have, my lord, any other opportunity to move to where we immediately went to the, my lord, vacation bench, my lord, and got an interim order which is still today subsisting.
Yes. What right do you have? Do you have any legal right? When you approach the writ court is the court of equity. What is your legal right? The court has held in the division bench of this court has held that the authorities were right in holding that you do not have a right to stay there. Under which authority of law are you?
Institute appropriate proceedings and let them evict.
How soon will you vacate? Give an undertaking.
No proceedings, my lord, against us as of today.
Under which provision of law are you paying any money? Nothing of the sort. Government property you are holding. It's what is the authority doing?
Here, Lordship. This fish market was originally constructed by the erstwhile HIT, that is Howrah Improvement Trust, sometimes in late 90s. Howrah Improvement Trust, there was altogether 222 stalls. Out of that, 20 ice stall and 202 fish stalls. Pursuant to an order passed by the division bench in a matter, my lord, allotments were made. Considering the number of applicants and the stalls, these 4 petitioners were given a big stall.
4 petitioners.
4 petitions. There are 4 petitioners.
Big stall.
Big stalls.
All right.
Page 18.
And since then, they were carrying on business there. They did not raise any grievance against that. Sometimes in 2003, they raised a demand.
No, don't go to all those things. Tell me from 2017 when the order.
Here I want to say this because earlier the control and management was in the hands of the Howrah Improvement Trust. In 2012, the control and management was taken over by KMD. Since then, my lord, we found that out of these 202 stalls, my lord, 25 stalls were never allotted to anyone else.
Oh, 2017, the court has come to an opinion that they were illegally holding the stalls. What were you doing from 17?
My lord, since 17 time and again, my lord, we are trying to, my lord, persuade them to vacate.
How you have persuaded?
My lord, we have repeatedly told them.
Show me something.
And my lord, some other such unauthorized occupiers had also moved a writ petition. Relying on the division bench judgment that is of 1997.
You tell me what steps you took to get these person go out.
My lord, here we have repeatedly, my lord, asked them to vacate. No document I can show.
Your men are also involved in this. Otherwise, how could an unauthorized occupant hold on to a stall for so long?
So, my lord, the authority, KMD authority had decided that since these 25 stalls to be allotted, since the KMD is losing revenue.
I am aware of it because I am handling matters and I've passed order in a few of them.
Yes. There are several writ petitions were moved because of those pendants of the writ petitions. We could not take.
Since what is your rent that is due? Since when?
No,
Never
116.
paid.
Never
116.
Never
We are
paid.
paying rent. 116 stop.
Yes, that
yes,
was
116 we
lawfully
are paying.
allotted. We are
Exactly.
not on that. And it is an admitted fact. It is admitted by them that due to paucity of their accommodation, they occupied this stall number 16, and twice they moved. And
Anyway, now since the court has not given you any
another vital.
This court is also not granting you any relief. You give an undertaking when you will vacate.
My lord, one very vital fact they have suppressed here. Not only this was affixed on the wall of that shop. Miking was done
in May.
Yes, miking was done because 25 stalls we proceeded to, my lord, we have floated a tender notice.
Yes,
we have completed the process. Process is completed.
And has this stall 16?
Yes, we have got H1 bidder. We are in the process of
handing over the stall.
Handing over
so
the
you
stall.
cannot stop that.
And challenging that, my lord, that tender notice, another unauthorized occupier had moved a writ petition. Writ petition was dismissed. Appeal was preferred. The honorable division bench dismissed the appeal. Not only that, their division bench clarified that Honorable Justice Umesh Banerjee's order 97, which they are relying on.
Yes, when will you vacate?
So that I have to take instruction, my lord, and come back. We were, my lord, never May 19th, May, my lord, notice. 7 days we received last day before vacation.
No, it is submitted that it was
Miking was done.
Miking was done and everything.
And tender notice, there is no whisper in this.
And there is a specific provision, my lord, how it has to be added.
If I am not wrong, someone from this petitioner's family had participated in the tender.
And it is all right, no difficulty. It is an open tender and everybody can participate.
Yes.
There is no difficulty with that.
We have got, in respect of this stall, we have got H1 bidder and the process is completed. We are in the process of issuance of.
You come up with a report. In the meantime, they'll take instructions. Achha,
take it up on Friday, my lord.
This Friday?
Monday, monthly list.
Monthly list, I do not want to touch. Tuesday. Achha. The petitioner seeks extension of the interim order passed by the court on 3rd October 2025. Stop. Upon hearing the parties, it appears that the decision of the respondent authority passed on 7th February 2017, holding that the petitioner does not have any right to claim regularization of occupancy of stall number 16 in the Howrah Fish Market, was affirmed by the Honorable Single Judge and the Honorable Division Bench.
Honorable Division is in some other matters.
Not in this matter, my lord, not.
In other matter.
By the honorable single judge way back in the year 2017. Stop. Similar order passed by KMDA was not interfered with by the honorable division bench either.
This is the order.
Stop. Next. The learned advocate representing the petitioner is unable to show before this court any right of the petitioner to hold on to the subject stall, as no formal order of allotment was ever issued
Tuesday.
in its favor. Stop. Next. The
5th November or May.
learned advocate representing KMDA is KMDA opposes the prayer for extension of interim order. Stop. It has been submitted that stall number 16 was put up in open auction, and KMDA is
Tender process is complete.
and the tender process is complete. KMDA is at the stage of handing over possession of the subject stall to the H1 bidder. Stop. Next. The learned advocate representing the petitioner is directed to revert with proper instruction as to when the petitioner will vacate the subject stall in aid of KMDA for handing over the possession to the highest bidder of the public auction. Stop. The matter is made returnable on 4th November.
Tuesday.
And by 4th, you are not throwing him out. By 4th, you are not throwing him out.
Kindly records that. Kindly records his submission. It is submission only. Only submission. His assurance, his officer is not giving assurance.
I am giving
kindly
assurance. You will not be evicted by Tuesday.
By Tuesday. All right. Next.
Maybe afterward.
But I appear for the respondent number 13. But possibly, my lord, your lordship doesn't have jurisdiction, my lord, to determination to take up this matter. But this is a police in action matter, my lord.
All right. Let the petitioner.
But I am appearing for the respondent municipality. My lord, it appears that the reliefs have been sought for against the state, and the matter is relating to a police in action.
Police in action.
And my lord, this matter has got a long history.
All right. Police in action.
Not only police in action, but also against the purported administrative action of the respondent authority in putting padlock
Prayer is
in
against
presence of the
respondent
putting by the respondent miscreants in presence of the ward councillor as well as the police personnel.
Very well. So go before the police in action bench.
Not only the police in action, my has been my chamber has been locked under the key.
May I tell you?
Who has?
Private respondent.
Yes. How does this bench have determination? Just satisfy this much.
Since my lord, the municipality has been involved in this matter.
Yes.
What councillor, chairman has been involved. What councillor has been involved. Local miscreants has been involved.
Everybody involved, but Group 9 bench not taking a
Specific prayer in prayer A and prayer B.
Well, your lordship kindly have
Opening the padlock by the police authorities.
No, my lord,
that is the
miscreants.
Kindly look at prayer.
Your lordship kindly supplementary affidavit.
Kindly look at prayer.
No, but then if
And
everybody is raising objection that this
my
bench
lord,
doesn't
you
have
was pleased
determination,
to
why
pass
will
an
this
order
bench?
for demolition upon giving hearing to the parties. That order has been carried out. Demolition made. I would just
on
1 minute.
12th October,
One trade license, online trade license has been.
Learned advocate representing all the respondents submits that this bench does not have determination to take up the matter. Stop. The primary relief sought for by the petitioner is against the police.
Against the police.
But not
Stop. In
the deal is to move before this court only.
all right.
Yes, has to.
The 24th October.
Yes.
Copy which has been served. That
All right.
deal is granted to move before court number.
All right. All right.
Your lordship kindly.
As As this bench does not have determination to take up this matter, let the same be released from the list of this bench. Now a number is there. What is the use of taking away the leave?
Leave was for the regular bench.
Let
They
me-
obtain another leave only to move for this. Regular bench, not vacation bench.
That was on vacation.
Vacation bench, but the number, since the number is there,
24th
my
of
land
October.
mention.
No, 24th of October, if there is a leave, it was mentioned, so leave was granted, and it leave is only for the numbering. So it will go before the regular bench now.
That's it. My lord, my land friend should mention it before the appropriate bench with
Yes,
the same
yes.
number.
Let the matter be placed before the regular bench,
Yes.
having determination.
You'll also kindly specify the time.
Notice of inclusion shall be served by the learned advocate for the petitioner upon all the
All the
respondents.
All the parties.
Your lordship, I am praying for interim protection, my lord.
Bench doesn't have determination.
In this
If that is
supplementary
the
affidavit,
absolute
my
mother,
lord,
we have to argue he
in
is
this
not entitled
supplementary
to in
affidavit,
law.
the jurisdiction of this bench has been invoked.
No, you
In this supplementary affidavit.
you take leave of the other bench.
Number 4, who is the officer in charge?
Item 4.
Well, hurriedly that writ petition was draft of the writ petition was prepared.
Now
After my lord, I moved the supplementary affidavit, my lord.
By
In this supplementary
you
affidavit, your
cannot
lordship,
invoke jurisdiction.
in this supplementary affidavit, in your lordship determination has been invoked.
That also
By
nothing has been
supplementary,
served upon
can
us.
you invoke determination or jurisdiction? You cannot. Your main petition is something else. Yes.
Your lordship kindly pass a direction that the matter be listed, my lord, very shortly, my lord.
You
mentioned it before.
mention it and get it done.
This is my application, my lord. I am
I'm great.
for the petitioner. His application is challenging the e-auction notice issued by the bank in respect of my property, my lord, which I got by inheritance from my mother, my lord. The last occasion,
Yes, my lord.
they have
I have
filed-
already filed an
This
affidavit.
is my reply to their opposition, my lord.
Yes. Who's for the bank?
I am for the bank.
Yes. What is your submission?
There is a maintainability point involved in this matter also.
Yes.
So I have a very good case on merit. First, let me kindly take up the maintainability point. Lordship, their main contention is the challenge of this page and the e-auction. Had that been the actual case, they had given a representation in the year 2019 to the concerned bank. They could have approached before the section 17(4), that is the DRT tribunal, which was having the appropriate thing. They does not do that. They come up in 2024 and file their writ petition in this court. All this action was on behind my back, my lord. All this procedure, I am challenging the process, the entire process. Alternative remedy, the SARFAESI Act, all these processes gone behind my back, my lord. On
Now, what is the stage of the SARFAESI?
the property has been sold.
Property has been sold.
Subsequently, buyer has been. It is not their property.
Yes.
Sale certificate has been issued. It is not their property. Only one thing that has been. In 2019, property has been sold. Sale certificate has been issued. Indenture of sale has also been done. Well, kindly see. Last year, yesterday, the land of record of rights standing in my name. I am telling.
But then record of rights is not the entire.
Done, my lord. All this process has been challenged under this application, my lord.
But here you cannot challenge all these things. The law doesn't give the writ court so much of power to look into all these things at this stage.
1986, the petitioner interest money already sold, my lord.
How the bank disbursed loan?
1986, my lord. Their petitioner interest money sold the property. How
the registered authority has registered the document in my in absence of my personification, my lord.
But all these factual issues.
Disbursed loan by on the basis of the forced document.
Yes, a forced document.
Taking the statement number 10 as a absolute position of the absolute, my lord. Kindly see.
Affidavit in reply filed in court today is taken on record. Upon hearing the submission made on behalf of the petitioner, the private respondents and the bank, it appears that there are several factual issues which are required to be adjudicated. Stop. The petitioner challenges a sale which took place in the year 2019. Stop. The private respondents Who is in possession? Who is in possession?
Bank already sold the property, my lord.
Acha. The factual disputes, paragraph D, cannot be adjudicated by the writ court. Stuff. As the sale already stood concluded by issuance of the sale certificate, comma, the writ court is not inclined to enter jurisdiction in the matter. Stuff. The instant writ petition is disposed of with the observation that it will be open for the petitioner to challenge the action of the bank before the appropriate forum in accordance with law, if so advised.
How the document has been registered, sale, taking the position of the respondent number 10 as absolute, my lord, without personification of me, my lord.
Yes.
Item number 5.
My lord, item number 5, my lord, I am appealing for the petitioner, my lord. If your lordships kindly allows me to appear online.
Certainly, you will be permitted to appear online.
My lord, on the earlier occasion, your lordship directed to kindly consider the order passed by your lordship on 24th 9 2025, my lord. On the earlier occasion, only a report file was filed under the signature of BL and LRO, my lord. Other than that, nothing has been complied with, my lord.
My lord, last occasion, my
Nothing
lord.
has been complied with.
My lord, kindly see the order dated 24th of September 2025, para 5, my lord.
All right. You file an affidavit. Where is the affidavit?
My lord, here. Last year,
Copy served?
no, my
No,
lord.
my lord.
He is
All right.
my lord today.
A report in the form of affidavit by the respondent number 7 filed in court today is taken on record. Stop. Let copy of the same be served on the learned advocate representing the petitioners. Stop. It will be open for the petitioners to file an exception to the report. 2 weeks
My lord. My lord.
by 14th November. 3 weeks. List the matter on 24th of November.
My lord.
Grateful to your lordship, ma'am.
Under the heading adjourned motion.
My lord. Grateful.
I'm appealing for the petitioner, my lord.
Your Lordship, Mr. Mandal is appearing in this matter. He has gone through a eye surgery, Your Lordship. So, if Your Lordship can kindly keep this matter 1 week after, Your Lordship.
What is it about?
Well, the one person, same person is doing two government jobs under two names.
Two names?
Yes, under two names. And I made representation before the DM concerned.
Who are you?
I am the person who applied for the same post, one post. Well, instead of my
And how many salaries is that person taking? 2 salaries. One person, 2 salary.
and representation, my lord, just representation is at page 39. Two voter identity cards.
You want this to be considered?
And a report on the basis, and an inquiry be conducted by the district.
You have instructions. Then please give.
Somebody then kindly make it not this week, Your Lordship.
Why?
Because I am not assisting him in this matter. The other junior, she has the instruction. Your
I can see names of 2 juniors assisting Mr.
None
Mandal.
of-
Nobody is here.
No, Your Lordship. Kindly make it not this week, Your Lordship. I'll provide it on the next week.
On the prayer made on behalf of the learned advocate representing the state respondents, hearing of this matter stands adjourned till 4th of November. Let written instruction be produced by the learned advocate representing the state respondents on the adjourned date.
Date of adjournment?
4th of November.
My application.
Yes.
I am appealing for Union of India. If your lordship looks at my lord's order of 7th of August, Lord, this was a contract that the railway had granted us. We are enjoying an interim order. Lord. This was a contract that railway had granted us, giving us a certain period of delivery.
that period of delivery in the purchase invoice itself, it had mentioned that if you have any problem with the period of delivery, you write to us. So we write to them, they change it twice, and finally third one, they revert to the original one. So we assail that before your lordship here, saying this is unconscionable and it's an illegal, arbitrary bargain. During the pendency of the writ petition, they issue a cancellation advice. If your lordship looks at my lord's order of 7th of August, this is the first order that your lordship has been pleased to pass.
Yes.
No, that's a different thing.
The respondents are restrained from taking steps for recovery of the general damages until further orders. Yes.
But I'll paragraph 4, your lordship will kindly request. Apprehending that the authority may take coercive steps at the date for delivery of some of the articles expired in the meantime. During the pendency of the instant writ petition, a cancellation advice dated 4th August 2025 has been issued. The petitioners are aggrieved by the same. Prayer has been made to permit the petitioners to come up with a subsequent application. In the meantime, restrain the authority from taking any coercive steps against the petitioners. Leave is granted to the petitioners to file an interlocutory application, bring the subsequent fact on record along with the prayers, stand adjourned till so and so. The respondents are restrained from taking any steps for recovery of the general damages as indicated in the cancellation advice dated 4th August till 29th until further order. This, your lordship will please to extend from time to time. Kindly have a look at the can that we filed, the application pursuant to your lordship's order.
There is no contract.
So I don't know why he keeps saying that. If he could just that application, kindly have a look at the cancellation advice. Page 24, if your lordship kindly has a look at. To Tecma Engineering, that's the petitioner before your lordship, 4th of August. This is what is referred to in that order, my lord's first order.
Yes.
There your lordship will see penalty imposed, recovery of general damages of 34 lakh so and so, requested to deduct so and so. This, my lord, has been pleased to stay. Now, my lord, when the matter was taken up next, their contention has been that the writ has become infructuous. So today they are to indicate to this honorable court why they keep saying that, then I'll be able to meet it. Not otherwise, I'll address your lordship on what is remaining in the writ petition.
What was the main prayer in the
Yes.
setting aside the modification advice?
Yes, the modification advice.
Admittedly, the modification advice does not subsist because it has been cancelled. Your contract or whatever has been cancelled.
Yes, but
And
this
what
is
remains.
Well, what remains is what has happened subsequent to filing.
Yes.
So that, which is why your lordship's order is there, taking into account subsequent facts which have arisen during the pendency of the writ petition. But my writ is that you had to give me enough time to supply the goods in the manner that RDSO has certified my production can be.
But in the meantime, you've got enough time. You could have filed a fresh writ petition. See,
that
interlocutory application, the prayers, the facts and everything are quite different from the writ petition. By way of an interlocutory application, the scope of the writ petition is being expanded.
I agree.
To a lot of
that your lordship is absolutely right. But the only thing is, thus the foundation of my challenge is this writ petition.
Yes.
So this writ can't go, which
Let
is
the
why
writ remain, you file the other one also. Then it will be seen, affidavits and everything will be there. Otherwise, it cannot be decided.
Very well, madam. I shall do that. Kindly keeps this writ pending, because my only difficulty is that despite your lordship's order, now when I'm going to, so I am naturally an enlisted vendor with the railways. Now when I'm going to take money for other contracts, they're deducting this and giving me, despite your lordship's order. That if my lord clarifies that this amount can't be deducted in this way. Your lordship
because their claim for damages remain.
Which your lordship has stayed, my lord.
Yes.
Pursuant to your lordship's order, if there's a stay,
True.
railways can't overreach the court and say, I will do something contrary to an order
Yes,
of court.
it's certainly-
My lord, I bow down to your lordship's observation that this
Certainly
I'll have
cannot
to
do
do.
that, but then
The cancellation, I'll challenge separately. But your lordship's order is invoked
cancellation
today.
includes the recovery of damages part
yes,
also.
yes. I'll do that together.
It's
But
not
the fact is, my lord, there is an order today because your lordship fell. Because, my lord,
Yes.
I'll tell you, lordship, if I succeed in this writ petition, then the cancellation is banned. Because the RDSO certifies how much production I can make. Based on that, they award the tender. Then they give timelines which are impossible for somebody to.
Isn't there any in-house grievance redressal procedure?
No,
laid
Milord,
down?
not to my knowledge. They have these special conditions contract, general conditions of contract, but that is different. But here I'll challenge this separately.
No.
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 How can it be no? You check up, there must be somebody to look into all these things.
But I'll challenge this and come back. And Milord, would it be your Lordship's pleasure to keep this sometime next week? I'll have the fresh writ also taken up, Milord, and then we can come back and trouble your Lordship together with this. Because if this goes, that will not survive, Milord. And Milord, only one thing in this.
But at present, there is no contract, no agreement, Milord. And his agreement.
Assuming that the agreement was there, the contract was subsisting, then who would have been the appropriate authority before whom the petitioner could have raised a grievance?
As such, there is no, but.
There is,
and
to my understanding also, Milord, my learned senior friend is right. There is no such authority before whom I can go.
Who issued this
and
cancellation advice?
Whatever we have taken steps, Milord, as clause 6, Milord, page 44. Page 44, clause 6. Whatever steps have been taken, that is pertinent to clause 6. Yes, page 44.
Security deposit
Yes, Milord.
is waived. Being RDSO approved form reserves the right to cancel and recover the amount
Yes.
as general damages from any contract.
Yes. And he has agreed, that's why Milord tender was given.
Correct. So that can be done. Your Lordship has seen.
Yes. Until date,
But then why will the writ court enter into all these contractual disputes?
Well, these factual disputes, Your Lordship need not enter. I will be able to.
Factual contractual dispute is there.
Yes.
Milord, I'll
The court enter.
that I'll be able to probably not. My only thing is that today this order of August is there. Railways, no one has preferred an appeal.
Before the regular.
But I have no other forum, Milord.
Please come.
But maintainability, I'll be able to satisfy Your Lordship. If Your Lordship is dismissing it on the ground of contractual dispute,
Contractual dispute.
no, then I'll give bear with me for 2 minutes, Milord. I'll just satisfy Your Lordship
Yes.
on the maintainability aspect of it. Milord, this is now, these issues have now come forward before this honorable court. Milord, two aspects that your Lordships have always insisted on. One is even in the contractual realm or a commercial transaction, everything has to be tested on the anvil of Article 40. There is also a concept of promissory estoppel and legitimate expectation. Well, a recent Supreme Court decision, if I may just cite, Subodh Kano, MP power.
Also relies on MP power.
There is one that is Subodh Dekhedi. If your Lordship looks at 2024 SCC online SC 1682, this is Subodh Kumar Singh Rathore.
Relies on MP power.
Executive Judgeship within, please. If your Lordship gives it a cursory glance initially, there's an index which is there.
Well, kindly give me one copy. Copy judgment.
Open your phone. Find it out. This is a reported judgment. Why will copies be circulated? Yes.
But if your Lordship looks at, there is an index
Yes.
initially, which traces how the law has developed, factual developments, all of that. Lord, without troubling your Lordship, kindly come straight to paragraph 55, which looks at MP power and favorably relies on it.
Yes.
Paragraph 55. Thereafter, this court, in its decision in MP power management versus so-and-so 2023, exhaustively delineated the scope of judicial review of courts in contractual disputes concerning public authorities. The aforesaid decision is in the following parts. Scope of judicial review in matters pertaining to a contractual dispute. This court held that the earlier position that all rights against any action of the state in a non-statutory contract would be governed by the contract alone and thus not amenable to jurisdiction of the courts is no longer a good view in view of the subsequent rulings. although writ jurisdiction is a public law remedy, yet a relief would still lie under it if it is sought against an arbitrary action or inaction of the state, even if they arise from a non-statutory contract. The relevant observations read as are under when the offending party is the state. In other words, the contention is that the law in this field has witnessed an evolution and, what is more, a revolution of sorts and a transformatory change with a growing realization of the true ambit of Article 14 of the Constitution of India. The state, he points out, cannot play the Dr. Jekyll and Hyde game anymore. Its nature is cast in stone. Its character is inflexible. This is irrespective of the activity it indulges in. It will continue to be haunted by the mandate of Article 14 to act fairly. There has been a stunning expansion of the frontiers of the court's jurisdiction to strike at state action in matters arising out of contract based undoubtedly on the facts of each case. It remains open to the court to refuse to reject the case involving state action on the basis of the action is per se arbitrary. It is undoubtedly true that the writ jurisdiction is a public law remedy, a matter which lies entirely within a private realm of affairs of public body, may not lend itself for being dealt with under writ jurisdiction of the court. The principle laid down in Bareilly that in the case of a non-statutory contract, the rights are governed only by the terms of the contract and decisions which are purported to be followed, including Radhakrishna Agarwal, may not continue to hold good in light of what has been laid down in ABL and has been followed in recent judgments in Sudhir Kumar Singh. The mere fact that relief is sought under a contract which is non-statutory will not entitle the respondent state in a case by itself to ward off scrutiny of its action or inaction under the contract if the complaining party is able to establish that the action or inaction is per se arbitrary. My lord, it is showing this on this principle that your lordship had passed the interim order on 7th of August. My lord, the same query your lordship had put to me, I had to cross this hurdle on that day. Now, what is the arbitrariness here? My lord, there is a provision in the contract that is entered into between me and the railways that if I'm unhappy with the timeline that they have imposed on me, I can reach out to them. My lord, this
The contract comes into existence.
Well, now, once the contract says so, what is the scope that I can request your lordship to now indulge in if your lordship just turns around and looks at III, exercise of the same judgment, my lord? Exercise of writ jurisdiction after the contract comes into existence. May I, my lord?
Yes, yes.
This court held that even after the contract comes into existence, an action may lie by way of a writ to either obviate an arbitrary or unreasonable action on the part of the state or to call upon it to honor its obligations unless there is a serious or genuine dispute as regards the liability of the state from honoring such obligation. Existence of an alternative remedy or a disputed question of fact may be a ground to not entertain the parties in a writ petition as long as it is not being used as a smokescreen to defeat genuine claims of public law remedy. The relevant observations read as are under. After the contract is entered into, there can be a variety of circumstances which may provide a cause of action to a party to the contract with the state to seek relief by way of filing a writ petition. Without intending to be exhaustive, it may include the relief of seeking payment of amounts due to the aggrieved party from the state. The state can indeed be called upon, this part may not be called upon to honor its obligations of making payment unless it be said that there is a serious and genuine dispute raised relating to liability of the state to make the payment. Such dispute ordinarily would include the contention that the aggrieved party has not fulfilled his obligation and the court finds such a contention by the state is not a mere ruse or a pretense. I am not here for money. I am for performance of an obligation which is there in the contract itself, that they will look at the timeline within which I can supply the material, and that has to depend on my ability to produce based on the RDSO certificate. You know, this is a tender where I participate. I have to give a RDSO certificate. RDSO certifies, let's say I can make 100 metric tons of a particular commodity. I participate for 1,000 metric tons. For 6 months, they don't do anything. Then they impose a condition that you have to give the first within first 3 months, then again within next 2 months, and the entire quantity is given on me. And the contract says that I can write to them if such an onerous condition is imposed. I write to them, they change it. The change again is in a way where if if your lordship gives me the time from today and I seek 15 days, today is the 14th day, your lordship is giving me 1 day. Then that is not 15 days. Same thing they do. So I write to them saying, you're giving it to me in August when I had written to you in May and you're asking for supply in 1 month's time. This is not possible. What they do is they don't, this is the bit I want to harp on. They don't say that they don't have an obligation to recast the timeline. They recast it, but they revert to the first timeline that they had given, which had by then expired. So by the time I file the writ petition, this is what I assail. And this is what I show to this honorable court. So your lordship finds that while the writ is pending, they receive the copy of the writ, they issue a cancellation advice. Once they issue a cancellation advice, I come before this honorable court and said, look, while this is pending, they've done it to make my writ infructuous. Keeping in tandem with how the law has developed, your lordship looks at subsequent developments and passes this injunction. Despite this injunction, what Railways does is it doesn't allow me to even submit my bills with other vendors of the consignee. And from every time they come and make this argument that this is infructuous. Yes. You know, this order has been taken consideration of by this honorable court. It's a subsequent fact which is arisen after my foundational challenge has been preferred.
Show me your initial communication for seeking extension of timeline.
Yes, ma'am. It is an
48 my first objection.
Kindly have a look at page 48.
44.
Milord, before that, if I may just indicate one thing, Milord. Kindly have a look at page 44 once.
Yes.
16.
16. Milord, it is this that is the cornerstone of my case. 16.1. Request for amendment of those purchase orders that are available in IREPS module under contracts shall be submitted through IREPS only. If any condition or clause in this document is not as per the offer of the firm, the same should be represented within 7 working days, failing which it will be deemed unconditional acceptance of the supplier and no representation thereafter will be entertained by the purchaser on this account. Now, if your lordship now turns over to page 48, is my first representation that I make to them.
Immediately after the deal.
Immediately after the purchase order is issued, relying on 16 II, I make this. They act on this. Well, if your lordship sees the representation once, you have placed the...
Your work order is dated 28th of March, right?
March. I am giving on 7th of April.
So it's beyond a period of 7 days.
I have 7 working days. 28th March it comes, and
days.
they don't say that they won't act on it. They act on this. They change it. If I may just place this will highlight what is the issue with the purchase order. You have placed the above order on for manufacture and supply of 6,40,000 number of ERC with bifurcated delivery. Since we have to procure raw materials from outside approved sources, we require minimum 30 days mobilization time. Further, for offering raw material, minimum 15 days time is required. And after clearance of raw material, 30 days production time and to offer the same for inspection time is also required. Hence, we request you to kindly modify the DP schedule as below. Mobilization time 30 days, first to fourth lot DP 30 days time presentation, inspection time 60 days each. If the process inspection takes long time, it will be to your account. You're requested to kindly modify. And in the next one at page 49, I also identify what is my production capacity, which is certified by RDSO, based on which I participate in the tender.
Ultimately modify at page 75.
Well, the modification happens at page 75. Now, what I wanted to highlight, Look, page 75, kindly see 16th May. And please see the delivery period at serial number 1. They've taken it from 29th April. It's like your lordship is granting me 1 month, but that 1 month starts from today. 2 days time is given.
29th.
16th May is the first page 75, the date at right hand top corner your lordship will find. So they understand that this requires to be modified. And I am to be given April, May, June, July. But they eat away that 1 month extra that they give me. They issue it in May and they take the time from April. So I write to them saying, by this acknowledgement, you yourself say, and the next one is again 29th May delivery period till 29th June.
If you do not deliver the serial number 1,
yes,
then you cannot go on to 2.
I cannot go on to 2. 2 also, your lordship, kindly see. This is dated 16th May. The time that I'm given is 29th May.
No, 29th of June. 1 month.
The amended.
Amended one
is 29th of June.
29th of June, it's refixed. You get 1 month's time. With number 2, there is no problem. It's with serial number 1. When it is issued on 16th of May and it is from 29, it's like giving retrospective effect.
That's it. That's it. That is it. Milord, I will not argue anymore.
Why couldn't you go deliver serial number 2?
Milord, I have to do serial number 1 first. Your lordship will find it's there.
They are not independent.
PO serial number 001. Please have a look at delivery period.
Yes.
And PO serial number 001. Then 002, then 03, then 04.
And same consignee.
And same consignee. But it is just this. The arbitrariness is in the retrospective operation of this 16th May thing. And all other follows suit.
No, that I can follow.
This is my case.
How do you get over this?
Till date, Mulad, he has not supplied any materials.
You have cancelled, so he could not have.
Yes.
He sought extension of time for supplying.
Yes.
You permit the extension, but from a belated period of time, for which he could not supply. What will be your reply to this?
Well, at present, there is no scope.
There is a person standing behind you. What is his explanation?
Lord, while he takes that instruction, just one more, kindly have a look at page 82 once. The next one. When I write to them, again, they understand they have to modify. Lord, what happens is, there are certain very big players in the market. Small ones are actually, please have a look at page 82. This is given as 27th May 2025.
Delivered on 29 April.
And delivered, amended, refixed 29th April. This is the arbitrary. So from 16 July, because I write to them again, they can't get out of 16 II, they do this to me now. So 27th May, so I am, the day they issue this, I am on default. And the moment I come to court, they reject it.
Yes, what's your explanation?
Mulad, after complying all formalities, Mulad, they have offered. Mulad. Now, Mulad, what has happened on 8th May, Mulad, page 72. On the one hand, they are paying extension. On the other hand, Mulad, they have cancelled next page. They have cancelled the inspection.
Cancel the inspection?
Yes, Mulad. Page 72 and page 73. Kindly see, Mulad.
Yes.
On the one hand, they are praying for extension. And on the other hand, on same day, Mulad, they have withdrawn the inspection.
Withdrawal inspection means? We are withdrawing our call number such and such means? Call number means what?
Call number means the materials which they are willing to supply, that should be inspected. Actually, they have no materials. They have no materials. Inspected, but they are praying for time. And on the other hand, when we are giving time, they are cancelling the inspection.
Yes, my learned friend will read out that thing and then make the submissions.
Yes. Until that, this is the extremely important materials, elastic railway clip, this relates to train operation. These are not the ordinary materials. Extremely important materials. Until date, they have not supplied.
This is my letter.
They have
At
got
page
enough time.
72,
And
I
after
am writing on 8th May saying my period has expired on 29th.
following,
I have called you for inspection once, you've not come. My second one also, now I'm having to withdraw. Kindly compare it once with page 75.
and
My
after
delivery
comparing
period
all
expires on
formalities,
29th April.
they have offered. They have agreed the sign.
I did not follow. You just tell me with regard to page 75.
बस তো দেখে বোঝা যাচ্ছে সেই 79 বদমাশি করে আগে প্রেজেন্ট করে
Page 48.
Yes.
Keep all these papers side by side. Page 49. 7th April, the petitioner writes to you for extension of time
Yes. 7th
or modification of the delivery date.
Yes.
7th of April. And then 16th of May, you give him the communication that I give you time till 16th of July. Right. So from 16th May, he gets 2 months time.
Yes.
May is the communication, June and July, 2 months time. But see, from 29th of April, right? How will the petitioner know on 29th of April that he was given extension till 16th of July for delivery of the materials? 29th April, is there any communication or immediately prior or after 29th that yes, your timeline for delivery is extended?
কিছু নেই No, Malad, it's not there.
So 2.5 weeks goes between 29th April and 16th of May.
And 82, Malad, they reshifted back to 29th April. Page 82, your lordship has seen. When I write to them again saying you've eaten up my 2.5, 3 weeks. Page 82, kindly see from 27th May this is being issued and the delivery period is now from 16 July. It's getting refixed to 29th April. So I'm already in breach.
Kindly see page 66.
Yes. 66. 15th April.
modified
Hmm?
modified করেছে এটা ফার্স্ট রিজেক্ট করেছিল আমার বারবার বলার পর ওটা মডিফাই
15th April, what my learned friend is showing, they rejected. Then I write again on the next page on 19th April saying this is as per your clause. And I quote the tender clause. And then they modify it again. And you know, these documents at page 75 and 82 are their documents. They modify it. Modify it retrospectively. In May, they say your delivery period is over in April. ওই দুটো লোক আছে না ওদের থেকেই নেবে অন্য কেউ পেয়ে গেলেও ক্যান্সেল করে দেয় ওই দুটো লোক আছে ইয়ারসি ক্লিপে ওদের থেকে নেবে
On 29th April. Kindly have a look at page 43, my lord. Kindly have a look at page 43.
Yes,
At the bottom.
yes.
PO date was last date was 29th April. That's why from 29th April extension was given.
That I could follow.
Yes.
But then you communicate on 16th of May that the extension is granted.
Yes.
Even my lord, 16th of May, my lord, they have given, they took enough time, my lord. They got enough time. In spite of that, they did not supply.
Yes.
My lord, even after 16th May, my lord.
16th May.
Yes, my lord, after communication, this order, this notification, my lord, they got enough time. Even after that, my lord, they did
Time
not
till?
supply.
Time till?
For supply of materials.
Till 16th of July?
16th July, my lord, but no supply has been made. No supply has been made.
But then page 82, you have revoked it.
In 9 days' time. 11 days' time.
From 16th July.
27th May, they say by 29th I should have given. And the next I have to give by 29th of May. This thing is designed.
No. There is some mistake somewhere. Page 82, 27th of May.
Yes, 27th May. Well, there is no mistake. This is why we say it's arbitrary. Well, your lordship will see, then amend it. So delivery period serial 1 from 16 July, which is at page 75, it's refixed as on 29th April.
It cannot be.
Look, that is what they've done.
29th April is the first
Well,
date
if
within
you're-
which
that's
you
right.
have to
Well,
complete your delivery.
Well, this
Right?
is what we were saying. What your lordship is opining it can't
was
be is what we
16th
were
of
saying.
July is the date. You sought for 2 months' time.
Yes. So when they give that, in page 75, I write to them from what your lordship has rightly pointed out, that you've taken away some much time of mine.
No, but then, even then, thereafter also you get 2 months' time.
Yes, my
You
And they
can have
in 11
endless
days time. If 16th of May had been in vogue,
You cannot have
it is
endless
something
time.
else. Yes. If let us say page 82 is not there, then 16th May stands. My problem is 82. In 9 days' time, they revert to the initial schedule of 29th April. Well, your lordship has correctly caught on to it, my lord.
Page 44,
Yes, my lord.
clause 16.
Yes, my lord.
Request for amendment of the purchase orders.
Yes.
Right?
Yes.
What are the things that you could make a request for? Amendment, does it means the amendment of time schedule? The initial time schedule is only 1 month. How can you extend it for so many days?
No, not if your lordship sees, if any condition clause in this contract is not as per the offer of the firm.
Yes.
So that's why I write.
Delivery schedule is 1 month.
So in 16 II.
No, sir. I'm not
May I just come back to 75 and 82 once?
75 and 82, 2 months time given to you.
May I just once, 75 your lordship has given me 2 months time. As on 16th of May, I have time till 16th of July. 82 is 9 days from that. On 16th of May, then it's become 27th of May.
The petitioner is aggrieved by the
it refixes the timeline again at page 82.
Inaction on the part of the.
Lord, could I just forgive my interjection, Lord? Could I just once again try, Lord? As on 27th of May, I can't be expected to have completed So on 16th of May, you give me time till 16th of July, you give me 2 months.
Yes.
On 27th of May, you make that period expire by 29th of April.
No. It was 29th April refixed.
Yes,
but
Manoj.
even then you could not supply within 29th
Look,
of
29th
16th of July.
Deeply obliged.
Nothing you could do. 16th of July, you just fail.
Look, 16th of July not come. This is 16th of May at page 75 and page 82 is 27th May. It's within 9 days, 11 days.
On 8th May, my lord,
July hasn't come.
he cancelled the call.
My learned friend is saying that
Yes.
May, June,
They're
July.
confused.
Before July comes, they've reworked, they've changed it again.
It is a kind of fraud.
Sorry, there's no fraud. I'm showing from their document. May, June, July. So 2 months I asked, they extended from April to July. Then in May itself, within 11 days, they revert back to 29th April. So by the time, what had rightly fallen from your lordship, by the time 27th May comes with retrospective effect, they put that timeline. I could have understood if this was dated 27th August, that till July I did not supply.
Getting enough
Page
time, they did not-
82 is May. I don't get
time.
any time.
They did not supply.
First extension is from April. First extension is from April to July. The next one
And
makes
refix
it
was
back
done due
to
to
April.
they cancelled the call. That's why refixed was made.
The first modification, 77 is written to that.
And Milord, I could have understood that my lordship is right, Milord, that it can't be. There is no other. It is completely with a retrospective effect that they've done it. When you give me 2 months time extension to supply, and the time extension is granted on 16th of May to supply till July, then on 27th of May, you can't make it back to again 29th April, it's expired. This has prompted us to come to this honorable court. Page 75 read with page 82. I am not even given a chance to supply. The day the 27th May 2025 page 82 is issued, I am in breach by a retrospective effect. Look, May 16th May, your lordship has seen they gave me 2 months time till July. 27th May, they make it 29th April. This, the railways will explain to your lordship how 75 and 82 can happen together.
16th of July.
Within 11 days time, how can it, with retrospective effect, change the timeline for delivery? This is my writ petition.
From the date of
Page 82, your lordship has seen, Manoj?
See, page 82 also
Yes.
gives you time till 16th of July.
Yes.
No, my lord, your
Supply
lordship has,
the goods.
this is the amendment. My lord, kindly have a look at 82. Following amendments are hereby issued with immediate effect to this office purchase order.
Yes.
Delivery period from 16 July amended as 29th April. This is my writ petition. That as on
Because blood
27th May,
inspection was cancelled.
Just wait. You are not being able to clarify the query of the court. You have problems with the dates. And then you are interfering whenever he is speaking. Page 75,
Yes,
16th of May 2025. First of all, your initial timeline was 29th April.
my lord,
Then 16th of May, it is amended.
and it's 16th of July.
16th of July.
This is amended again with immediate effect at page 82 on 27th, where my delivery period is now made back to 29th April, issued on 27th of May. This page 82 is my writ petition, that the 2 months time that you give me to supply, you don't even give me that time to supply. I am immediately in breach.
You were in breach on 29th April 2025 when you could not deliver it. Prior thereto, you had sought for extension of time for delivery.
Yes.
Right?
Then they extend
Now-
that, giving me 2 months time to do that.
And thereafter, they revoked that.
Thereafter, they revoke that. They
So
give
you
the
challenge
extension
their revocation
and revocation retrospectively
retrospectively of the extended period,
of the extended period.
right?
Yes, my lord.
Now,
So I am therefore, my lord, which is why we were citing MP power. There is an aspect of promissory estoppel and legitimate expectation.
can you
Once
force them? See, first thing, this is a contract.
Yes, my lord.
The initial timeline, forgetting the
No, Your
dates,
Lordship is
it is
absolutely
30
right. My lord,
days.
had 100%, my lord. Had 75 not been there, I could not have asked before Your Lordship to make them issue 75.
True.
But in their wisdom, considering my offer, when they issue page 75 in terms of 16 II, then 82 can't be issued.
Right. In their wisdom,
Petition.
in their wisdom, they thought 75 was not rightly issued and they go back to 82
if
and
they can explain that,
revert back to the 30 days timeline.
Milord,
What do you say?
I-
It is their contract. It is, they think it that way.
Milord,
You knew.
I agree. But 16 II does not allow them to do that. Milord, the purchase order.
You say request for amendment of those purchase orders shall be submitted, right?
Yes, my lord.
There is nowhere mentioned that the timeline can be extended.
Please have a look at page 75 once.
They have themselves done it.
No, please have a look at the amendment.
Yes.
Please have a look at the amendment, my lord.
Yes.
Subject. Amendment number 1 to PO number dated 28th.
Yes, they have accepted.
Now, please have a look at 82.
No, sorry.
82 once, my lord, what they
I've
amend.
seen it.
Please have a look at what they amend, my lord.
They go back to the original time schedule.
They amend the original purchase order again.
Yes.
Because the original purchase order stood amended as on 16th May.
Yes.
But the second amendment, it
was not right according to you.
Yes, no, that's
yes. This I got it. The writ petition arises out of a purchase order issued by the Southeastern Railway on 28th March 2025.
Lord, may I just say one thing, Lord? If they give me these 2 months time, even now I'll supply. But they gave me 2 months, that 2 months they should give me, Lord.
কি বললাম? For manufacture and supply description টা তুলে দেবেন তো page 43 description. The time limit within which the manufacture and supply was to be made for the first for the first batch commenced on 29th March 2025 and it completed on 29th April 2025. Taking advantage of note within bracket 1. Now, of the note mentioned in clause 16 of the purchase order.
Taking advantage of note,
Of the note mentioned in clause 16 of the purchase order. The petitioner applied before the respondents seeking modification of the delivery period schedule and sought for an extended period for supplying the materials. চিঠির ডেটটা কি বললাম? বলিনি না 7th April. পরের চিঠি একটা দিল 7th of April 25.
That will be advantage of the network.
হুম কি বললাম পুরো
Taking advantage of the note.
হুম
Mentioned in clause 16 of the purchase order, the petitioner applied to the respondent seeking modification.
applied before the respondents on 7th April ঠিক আছে এবার হচ্ছে by a communication dated 15th April 2025, the petitioner was intimated that the item to be supplied is a critical one and the material is urgently required by the railway. Stop. The petitioner was requested to supply the material as per the terms and conditions mentioned in the purchase order, and failure to supply within the stipulated delivery period would attract penal provision as per the conditions of the purchase order. The petitioner was informed that the supply as per the purchase order is essentially required, and the request for modification of the delivery period was not accepted. By a further communication dated 25th April 2025, the petitioner was again intimated regarding non-acceptance of the modification of the delivery period. Stop. The petitioner was further intimated that the item is an integral component, not integral, integrated component of railway track infrastructure and directly related with the safety of the passenger. Stop. Non-supply of material as per contract would jeopardize maintenance of work related to track safety. By a communication dated 16th of May 2025, the petitioner was intimated regarding amendment of the delivery period. Stop. The initial delivery period the initial date of delivery was amended The initial date of delivery being 29th April 2025 was amended as 16th July 2025. Stop. Immediately on the next date, that is 17th May 2025, the petitioner sought further extension of time for supplying the materials. Stop by a communication dated 27/28 May 2025. The petitioner was intimated that considering the willingness of the petitioner to execute the work order, the date of delivery was refixed. Stop. The authority took note of the fact that by a communication dated 8th May 2025, that the petitioner sought for inspection of the goods. But immediately on the same date, that is on 8th May 2025, the petitioner withdrew the inspection call. Stop. The authority found the same to be an unfair practice on the side of the petitioner. Stop. The petitioner was intimated that the railway had no other option but to withdraw the subsequent extension granted with a communication dated extension modification advice. Extension of a modification advice dated 16th of May 2025. And the initial date of delivery was retained by the authority. Stop. Fact remains that now তারপর একটা line add up করুন, by a communication dated 27th May 2025, the
82
fact of reverting back to the original date of delivery by cancelling the modification advice was thereafter issued. Stop. The petitioner is aggrieved by the same. Stop. It has been submitted that even though the authority intend to extend the period for delivery of the items, but the petitioner could not utilize the extended time period, as prior to the extended time period coming to an end, the authority went back to their initial date of delivery. Stop. Next. It has been submitted that the authority could not have revoked the modification advice, revoked/cancelled or withdrawn the modification advice once the same was already issued. Stop.
But,
Yes.
may I take your lordship's kind leave?
Yes, yes. And when the writ petition was moved on 8th August 2025. Now, the writ petition was filed on 25th of July 2025 and the same was taken up for consideration by the court on 7th August 2025. Stop. The petitioner apprehended that the authority may take coercive action against the petitioner for non-delivery of the articles within the stipulated time period and sought for an interim order. Stop. The court restrained the respondents. Now, in the absence of proper instruction from the railways, the court had no other option but to restrain the respondents from taking any coercive step against the petitioner. Stop. Next. A supplement, a connecting application has been filed by the petitioner by annexing a communication dated 4th August 2025, whereby the petitioner was intimated regarding cancellation of the purchase order and the penal action that was sought to be taken. Stop. Today, at the time of final hearing of the writ petition, it has been submitted that if the initial modification of the if the cancellation of the modification advice is upheld by the court, then the subsequent cancellation order and the penal action sought to be taken will fall flat. Stop. Next. It has been submitted that if time is allowed to the petitioner, the petitioner is still willing to supply the materials. Stop. Learned advocate representing the railways submits that as the purchase order has been cancelled, comma, at this stage, comma, there is no scope to allow the petitioner any further time for supply of the materials. Stop. According to the respondents, the writ petition has become infructuous. Stop. Next. The court, after hearing the parties, has posed a question before the petitioner to satisfy the court with regard to the maintainability of the writ petition, as the same relates to a contractual dispute in between the parties. Stop. In support of the submission that the writ petition would be maintainable, comma, learned advocate for the petitioner relies on the decision delivered by the Honorable Supreme Court in the matter of Shubodh Kumar Singh Rathod versus Chief Executive Officer and others, reported in 2024 SCC Online, SC 1682, paragraph 55, wherein the court took note of the fact that judicial review may be exercised pertaining to contractual disputes concerning public authorities. Stop. Next. The court has perused the documents annexed to the writ petition. Stop. Next. It appears that the initial time period, as mentioned in the purchase order for delivery of the first batch of items, was from 29th March 25 till 29th of April 2025. Stop. The authority has itself intimated the petitioner that the timeline was being extended considering the willingness of the petitioner to deliver the articles. Stop. Thereafter, the action of the petitioner raised doubts in the mind of the authority with regard to the genuineness of the petitioner to supply the articles. Stop. The authority repeatedly intimated the petitioner that the articles were essentially required and non-supply of the same would jeopardize maintenance of work related to track safety. Stop. The petitioner was time and again put to notice that instead of execution of the supply, the petitioner sought to incorporate fresh condition in the contract. Stop. The initial time period within which the item was to be delivered was 30 days. Stop. The petitioner time and again repeatedly sought for extension of time for supplying the articles. Stop. The authority initially thought it fit to extend the time period, but thereafter, considering the conduct of the petitioner, the authority revoked the extension and sought to stick to the initial time period fixed for delivery of the goods. Stop. It will be highly improper for the writ court to decide as to whether the extension of time and thereafter revocation of the same for supply of articles extremely vital and essential for মানে কি এটা পাবলিক সেফটি নাকি একটা কি বললাম না essential for maintenance of work related to track safety কি দিয়ে শুরু করলাম সেন্টেন্সটা it will be highly improper for the
time and thereafter revocation of the same there are activities extended and then share for maintenance of work related to track safety.
হচ্ছে না কি বললাম ঠিক আছে ট্র্যাক সেফটি স্টপ করুন the railways are the best authority to decide within which an article which is so very vital for maintaining track safety is required to be supplied. Stop. The contractual dispute in between the parties, comma, in the instant case, comma, ought not to be adjudicated by the writ court. Stop. The court prima facie does not find any illegality on the part of the authorities requiring interference by the writ court. Stop. Next, in view of the above, the writ petition fails and is hereby dismissed. Stop. Dismissal of the writ petition will, however, not stand in the way of the petitioner to approach the competent forum for relief in accordance with law if so advised. এটাকে জাজমেন্ট
May it please your petition. I'm appearing for the petition in the matter.
Who is your other side?
Come up for the first time. We have served
List of election.
Enforcement Directorate, Union of India, other parties, and also the Registrar of Companies. May I file the affidavit of service?
Yes, please. Is anybody appearing online? Nobody is there.
Absolute violation of principles of natural justice. Two parts to the matter.
Answering respondent is?
Answering respondent would be the Assistant Director of ED and also the ROC, because ROC started the proceeding. I'll quickly indicate the facts.
No, but this
Very
is the
briefly.
absence of the other side. Whether today it will
We'll come
be-
back. We'll come back. But may I only indicate why this matter is important, in the sense why this is a matter where there is gross violation of principles of natural justice, and why they could not. In 2 minutes, I'll not take more than that.
No, let it appear in the list. Please come. None appears on behalf of the respondents. Stop. Affidavit of service filed in court is taken on record. Stop. 4th of November. Supplementary list.
I'm deeply obliged, Lady. There's only one difficulty, because I'll be praying for an interim order in the matter.
Yes, that is the reason their presence should be there.
Deeply obliged.
Yes.
What's your time for the respondent? Respondent.
কি করা যায় বলুন তো? I'll make it only not today.
Lordship, my lord can fix the matter any day in the supplementary list if your lordship pleases.
আজকে not today.
Any day. That is my humble suggestion.
Same position, we are not touching it, right? Otherwise, then again listing and everything, it will be a problem. Let it remain not today.
Then not tomorrow, if it can be
not tomorrow also.
Matter maybe come up on Wednesday.
Not Wednesday, maybe in the combined list, because I'll not come back immediately. I'll move forward. So tomorrow it cannot be taken up. All the list.
I'm for the bank, my lord.
Respondent.
My lord, strange thing is that if your lordship comes to the prayer of this writ petition once, he is seeking a relief against the bank so far as the surfacing proceeding is concerned. And he says, issue and appropriate writ release of the baby of the petitioner.
Baby?
Yes. Issue. I could not make head and tail out of this entire writ. The
Copy
ground,
and paste it.
Prayers, baby of the petitioner, to allow reasonable compensation to the petitioner. I mean, where does he get?
Copy paste.
My goodness, but she is a default. Her husband was a defaulter. She has an autistic child. Now, what will the bank manager do with the child? How will the baby be released?
What have you done to the property?
That has been no. It's sold. What happened is she is actually a partner in another partnership firm. She's not insolvent at all. Now we did take possession. Then she took help of local goons. She got repossessed, and then now again we took the assistance of superintendent of police, and we've got the possession back. That is the current status, and it will be sold off shortly. But what is she praying for? What relief does she seek? how the baby is related with this writ petition? Kindly come to the grounds and the prayers. It's absolutely frivolous, my lord. This is pending since
Learned advocate is
2024.
from the Alipur court. You will not.
2024, it is pending.
You
And
will not get the
what
learned advocate.
prayers.
Ashok to dekhi, none for the petitioner. Stop. Release the matter on 29 তারিখ করে দিন পরশু দিনকে learned advocate for the bank is who is present in court submits that the prayer of the writ petition does not match. Prayer A of the writ petition does not match with the facts of the instant case. Step. Let notice be served. How will you serve? There is an email. There is a phone number. Mail is also there.
I can serve through email as well as I
Please.
can call up the advocate also.
Intimating that the matter will appear in the list on 29th October 2025.
Grateful, Your Lordship.
Lista din na আমাকে
My lord, in item number 343, my lord, I am appearing on behalf of the petitioner, my lord. In this matter, Ms. Manju Bhuteria, senior advocate, is appearing, my lord. My lord, humbly praying for a week's adjournment, my lord.
If she is
Not this
appearing,
week, my
then
lord.
what has happened?
My lord, she's not come to court today, my lord. Only a week, my lord. Not this week, my lord.
Very well.
Grateful, my lord.
I beg to appear for the respondent bank, my lord.
I'm for the
Abonishwar is leading in this matter. She has not come to the court due to her viral fever.
Nothing, sir.
Kindly
My lord,
not
the
to
section
demand.
17, my lord, appeal before DID, all has been dismissed.
Next day we'll dismiss it. Not today.
Day after tomorrow, my lord.
Day after tomorrow? When?
Next week, my lord. Great.
Madam, I pay for the petitioner, Your Lordship.
For the ECL, I am applying for the ECL. I am paying for time to file affidavit in opposition.
Lordship, may I?
Otherwise, you do not have any objection if the matter is taken up today? You are ready with facts?
No, Leonard Senior is concerned of the fact that I am not. Leonard Senior instructed me to pray for time to file affidavit in opposition.
Mechanically, affidavit cannot be directed to be filed. I can dismiss the writ petition here and now. Where will you file your opposition? So you don't know what the matter is?
Lordship,
I don't know.
What is it?
Lordship, the petitioner is the buyer of coal from Coal India Limited, Your Lordship. His business is simply buying of the coal and just sell it in the open market, Your Lordship. Now, the issue involved in this writ petition is that whether the petitioner is liable to pay composition user fee or not. Your Lordship, if my Lord will kindly come to Annexure P4, it says this composition user fee is meant for the vehicle owners. Vehicle loans, not for the buyers like us, Your Lordship. So the notification is the Annexure P4 accompanied by a debit note which they have claimed as the composer user fees as rupees 2,90,000 and odd from me. This notification is under challenge, Your Lordship. I'm only a buyer of coal from Coal India.
Did you intimate the authority that you are not liable to pay this
Lordship,
fee?
I have intimated them via email. Everything was done, Your Lordship, that I am not liable to pay because I'm the only buyer of the.
Was there any reply from them?
No, nothing, Your Lordship.
Show me that
Yes, Your
document.
Lordship, kindly come to Annexure P4 at page number 24, Your Lordship. This price notification, which is under challenge, Your Lordship. Page number 24, P4.
Right. You say you are not liable to pay. Where did you intimate the authority?
Lordship, the intimation is not there, Your Lordship. The very day, 27/7/2022, it was under challenge and the debit note was issued in my favor.
You say that this is not applicable to you.
Lordship, after that, when this debit note as well as the notification reached to me, I approached this honorable court. Challenging
Without
this.
any challenge.
Lordship, this is under challenge. No.
Without any demand notice, you directly approach this court.
Lordship, because the debit note says that you are liable to pay 2,90,000 and odd, or you will not be entitled to participate in the e-auction, Your Lordship.
Please come.
The very moment
The petitioner is aggrieved by the price notification dated 27th July 2022, issued by Eastern Coalfields Limited. Lordship. Specific contention of the petitioner is that the petitioners would not be liable to make any payment in terms of the price notification. Stuff. From the documents annexed to the writ petition, and upon hearing the submission made on behalf of the petitioners, it appears that the petitioner did not approach the authority.
Lordship, may I? Lordship, this was not annexed, Your Lordship, so I cannot make a specific contention submission before Your Lordship whether they have done it through means written or representation or not. But it was done. It was intimated to it that they have reached. They have approached the authority verbally and through via mail, but that was not annexed annexed with this writ petition, Your Lordship, because this notification came to me and I approached them verbally, but there is no such writ petition, Your Lordship.
It appears in learned advocate for the petitioner submits that though the petitioners approached the authorities verbally,
Lordship,
intimating that the said notification would not be applicable in their case, but there is nothing on record to suggest that the petitioners challenged implementation of the subject notification on them. Stuff. Next, in view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioners to make a written representation before the authority, highlighting their grievances and disclosing how the said notification will not be applicable in their case. Stuff. In the event any such representation is made, the same shall be considered by the authority in accordance with law. Exposed.
May I, Your Lordship, may I take my once again time, Your Lordship. When this was filed,
what is your name?
Mine is Abhishek Shaw.
Abhishek Shaw. Are you there in the panel?
No.
Then, whose appearance are you noting down?
My senior and Prodipto.
And your senior is not here. How can the appearance be recorded? It cannot be recorded. Right?
My
if
Lord,
you
may I
want,
take my Lord?
Your name can be recorded.
My Lord,
right.
My Lord, this notice came to me. I went to them verbally, said that it's not applicable. And after this writ petition was filed, your lordship, it is a fact that they did not claim that money to me, that 2,90,000 and all.
Don't make the representation if they
No, your
don't
lordship,
make it
that is
effective
my
in your
lordship.
case. It's
Lordship,
it's
no,
your
I will-
choice. Next.
My lord, affidavit of service.
Yes, yes. ওনার নামটা লিখে দিন তো, অভিষেক শ। Not today.
348, my lord. I prefer not today, your lordship. I'm praying for an accommodation only for today, your lordship, under instructions, my lord.
Tomorrow it will appear?
Yes, my lord. My senior has not been able to come today in court today due to
Yes.
personal reasons. That is the only reason I'm seeking an accommodation only for today, your lordship.
You are for?
I'm for the respondent number 4.
Only for?
Yes.
Not the others?
But I am the answering respondent.
You are the answering respondent? কালকে থেকে supplementary list দিয়ে দিন. Tomorrow supplementary. Yes.
Can it be day after, my lord?
You want it day after? All right. List এর নিচে কালকে দিয়ে দেবেন, আগামীকালের পরশু দিনের ডেট দিয়ে।
Gratefully, lord.
My lord, matter is infructuous and I am not pressed this application.
Who are you?
The petitioner.
You are the petitioner? লিখে দিন, infructuous. And are you the advocate on record?
No.
No.
Sampurna Chatterjee on advocate on record, care of Ladishakar Ghosh, sir.
All right. Infructuous. Your name will be recorded. What is your name? Yes.
Grateful, lordship.
লিখছেন পেছনে?
$352, my lord. I'm praying for not this week.
Very well. আরে লিখতে থাকুন, একটা লিখ। Yes, what is the matter?
My lord, matter about my lord, environment matter, my lord, in which my lord, the petitioner in the residential area, my lord, one my lord, Almira manufacturing my lord business has been started by the private respondents. My lord, in the by that way, my lord, the painting, my lord, the bending sound and my lord, other sounds, my lord, hammering sounds, my lord, is caused my lord serious, my lord, inhygienic situation, my lord, to my clients, my lord. The client's wife, my lord, has become, my lord, seriously.
Yes, so you made a representation.
I have made representation, my lord. They caused inspection.
Yes.
My lord, they cautioned the other versions. My lord, when they came with notice. On that day, my lord, took steps. My lord, no sound was there. But they went away. My lord, they are, my lord,
Again
painting.
started.
They started. This is the my lord, situation. My lord, I submit to lordship, my lord, to take steps by the authority, environment authority, my lord, with the help of my lord, police and my lord, BDO. If the my lord, if the situation, my lord, if the situation, my lord, my lord,
If the situation continues, then it will be difficult for you.
my lord.
Yes. Total লিখুন তো. None appears for the respondents. Released on 4th November. Stop. Let notice be served upon all the respondents. Stop. Learned advocate for the respondents shall come ready with written instruction with regard to the functioning of the
Private respondents.
Polluting unit of the private respondent.
My lord. 4th November. Good.
359 to 360.
My lord, are my lord identical matters 360 and 361. I have instructions to withdraw, my lord.
Why?
But they do not want to proceed with this.
All right. Written instruction
Yes.
60 and 61.
Yes.
Dismissed as not pressed. Written instruction written with the records.
This is the written instruction
in
respect of item number 360 and this is 361. My lord, the rest two matters, my lord.
359?
Yes. My lord, the petitioner, my lord, in 2021 applied for.
Are you there?
Mr. Basubalik is appearing for the statement.
Yes, where is he?
He is engaged in courtroom number 34.
34, call him. Yes.
My lord, the petitioner, my lord, applied for grant of letter of intent or excise license, my lord, under the category restaurant cum bar. My lord, since 2021, necessary fees, my lord, were also deposited. Since 2021, they have not taken any decision. It is pending disposal.
Pending? Since 21?
Yes.
Any written instruction? Who is assisting Mr. Basumalik?
But only prayer, my lord, I am seeking that let them dispose it of, my lord, because I have already.
Where is your
substantial-
application?
Yes, my lord, my initial application, your lordship will find, my lord, starts from page 13, my lord,
Yes.
13 of the writ petition. This is the initial application. And thereafter, my lord, there was an amendment made in relation to Rule 9 of the 2003 rules, my lord. So, my lord, an application was also made in the, my lord,
Prescribed format.
prescribed format.
Right.
And the, my lord, from the life cycle of the application, my lord, it appears that it is in 2021, it was lastly pending before the superintendent of excise, my lord, for consideration. Life cycle, your lordship will find at page 23 and 23 of the writ petition, my lord. My lord, the last entry, my lord.
Yes.
And my lord, the last, my lord, representation was made on 22nd of March 2024, which starts at page 30, my lord.
Yes.
Lord, I not his brief to here. Kindly
Please
pass
come.
it over. Kindly pass
Pass
it
it
over.
over.
I informed him.
Call Mr. Basumalik. Or anybody who's assisting him. I'm passing it over. And 62 is also same.
62 is same.
21.
It is a different applicant, my lord.
Maybe.
We are appearing.
Yeah, he's there. Yes, please give 62. Why is it pending? Any specific
Into our
reason?
instruction, my lord. This falls under the within the postal regulation zone. So, my lord, we have sought the.
Why don't you intimate that you cannot get it or you need permission from the...
They have written in my brief at least.
Okay.
They have denied this fact. This falls under the coastal
regulatory zone.
But in our my lord, I have specific instruction. This particular
Clearance certificate regarding the coastal area for the proposed site. Mondarmati.
So this is
Let me see. Yes.
Paragraph.
Yes.
So they have
Apart from this excise license, did you obtain any trade license?
No, development authority also, my lord,
My
they
lord,
had to
because
take permission.
this, my lord, CRZ applicable, coastal regulation zone, my lord, this has in my humble submission no application apropos grant of an excise license. That only pertains to a construction.
But that construction
If
has to be
the
approved.
if the business you are running is in a property which is not being constructed in accordance with law, then license cannot be issued to you.
My lord, the hotel is already running paragraph 3 of my.
No, that's absolutely illegal. There is no permission for running hotel.
My lord, this does not also, my lord, comes within the coastal regulatory zone, my lord.
Now you challenge that.
But I'm giving him the
Let
copy.
them, my lord, dispose of my application, citing this reason.
They have communicated to you, page 20, I can see.
Yes.
To submit
And
clearance
my response,
certificate.
my response, your lordship will find at page 21.
All right, yes.
Thereafter, my lord, nothing happened. I have specifically stated that this does not come within the zone of, my lord, the coastal regulation zone.
The chief administrative officer specifically stated
Yes.
this to be followed. My lord, I have given the instruction. Kindly see of this copy, my lord. Chief administrative officer. My lord,
Which copy? Here.
this. They have cited.
Boundaries.
No, first page. Oh, yes. Now, my lord, he has not made this zonal regulation party also. He has not added as a respondent.
Please come. The petitioner is aggrieved by the action on the part of the excise authority in refusing to grant license for running bar cum restaurant at a site under the Mandarmoni Coastal Police Station. According to the authority, the site in question falls within the coastal regulatory zone. Stop. Paragraph. The petitioner, through her learned advocate, intimated the authority, not intimated, denied the stand of the authority that the site falls within the regulatory zone where license cannot be issued. Stop. Next. The paragraph, prayer has been made to direct the authority. Now, prayer it has been submitted that the restriction with regard to the coastal regulatory zone will not be applicable in case of the petitioner, as the subject hotel from where the business will be run is already in operation for quite some time. Stop. Every prayer has been made to direct the authority to take a decision with regard to grant of license in her favor. Paragraph. Learned advocate representing the excise authority relies upon the instruction forwarded by the Superintendent of Excise, Purva Mendipur. Stop. The observation of the coastal regulatory zone. Now, the observation on the coastal regulatory zone status, clearly indicating the geographic coordinates of the hotel from where the petitioner intends to run her business has been forwarded by the Chief Administrative Officer of the Institute of Environmental Studies and Wetlands Management, Department of Environment, Government of West Bengal. Stop. The coordinates of the hotel of the petitioner mentions that the same lies within the CRZ zone. The instruction forwarded by the authority mentions that the offered site where the business is proposed to be run has been constructed over the seaward side, within brackets CRZ-Roman 2, which is in contravention to the provisions of the Coastal Regulation Zone notification of 2011. Stop paragraph. As the authority has come to an opinion that the constructed site is within the restricted zone, accordingly, the prayer of the petitioner for grant of license cannot be allowed by the court. The writ petition fails and is hereby dismissed. Next.
Lord, let a copy of the instruction be not handed over to me, Lord. Because it is my specific stand that it does not fall within the ambit of my Lord CRZ.
I'll mention the coordinates over here for you to take things further. The coordinates are mentioned.
Later also, my Lord, they have only sought for, my Lord, a clearance certificate.
You do not have. In case you obtain a clearance certificate, this order I can pass.
My Lord, the Coastal Regulation Zone authorities, my Lord, humble, my Lord, submission, they do not have any power to issue any clearance certificate, apropos an excise license. They can only issue such an
construction.
Construction, yes.
The construction is. No, sorry.
Later, my Lord,
nothing in
which
that
I have
case.
annexed.
Next.
My Lord, that is not their stand.
363.
This is for the petition laid by Mr. Bhattacharya.
Yes.
This is a matter is coming from the Legal Services Authority. Now, my lord, I would be only requesting your lordships, my lord, to come to page 32 and 33. I think that the writ petition has become infructuous.
If you say it is infructuous, it is infructuous. Why will the court look
No,
at all these things?
but even then, my lord, it is my duty, my lord, to point it out to the court.
Page 30?
Page 32.
32.
32.
What was the relief sought for?
Reliefs which were sought for, my lord, kindly see the prayers.
Why did you file the writ petition in that case? Consider and dispose of representation for removal of illegal job.
And after, my lord, it appears from page 32 that.
Please come. Learned Senior Counsel representing the petitioner submits that the writ petition has presently become infructuous. Stop. In view of such submission, the writ petition stands dismissed as infructuous. Next.
My lord, I am for the respondent now. My lord, petitioner is the employee of a railway. My lord, his claim, my lord, before the live before the administrative tribunal. My lord, said
Very well. Today the petitioner is not here. I will not pass any order.
Okay.
You are there? Where is Mr. Ganguly? Here. Oh, ওটা possible হয়েছে না ডেকে দিন তো।
But it is my duty to point out, since this point has been raised in the other matter, that this matter also in this.
Same
matter
thing?
also, my lord.
Do you have
Yes,
the
they had
instruction?
sought for, my lord, this is running for 9 years and this does not, my lord.
Instruction we do not have in this matter, my lord.
In a
Earlier
similar
matter,
matter, there is instruction from the
Told law.
administrative officer which says that this place falls within the CRZ regulation.
Here, my lord, if lordship takes page 29 once, my lord.
Yes.
Fine, my lord. The
They have sought for
applicant-
clearance certificate.
Clearance certificate in reference to the above, they are by requested to submit clearance certificate.
Same thing is there.
Same, my lord. This
Is this also star in? That was also star, isn't it?
Yes, my lord.
This is
Star in FL restaurant cum bar.
Last one was star, isn't it?
Last one was star in resort.
And this is
Star in restaurant.
same.
Cum bar.
Is the property the same?
My lord, that I have to, my lord.
তাজপুর খতিয়ান নাম্বার 76 এটা বিপটা বার কর না একবার বাস সেমই হবে একটা বিপটা বার কর না একবার
আগের ফাইলটা দিন তো একটুখানি।
362 টা এক সেকেন্ড দেখো মানে
362 ফাইলটা 1 মিনিট দিন তো।
তুমি না দেখো বলদিও না রকম
This is different plots, my lord. Lordship may kindly compare page 15 of this writ petition with page 13 of the earlier writ petition. Plot numbers are different.
But then PS Mandarmoni Coastal,
Yes, plot numbers.
it will be within the same CRZ regulation.
My lord, dear lordship is aware in the Mandarmoni matter, my lord, names of 50 hotels have been disclosed by the PCB. My lord. This does not feature within the list.
Please come. The petitioner prays for issuance of excise license. Stop. The in a similar matter, comma, it appears that the authority has refused to issue license.
They have not refused,
No,
my lord.
not refused, has not issued the license, as the petitioner could not submit the clearance certificate regarding the coastal regulation zone. Stop. The proposed site from where the business will be run falls within the coastal regulation zone. Stop. Next. In view of the above, the relief sought for by the petitioner for grant of license for running business at a place which falls within the restricted zone cannot be allowed by the court. The writ petition fails and is hereby dismissed.
Lordship kindly records that it is my specific contention that it does not fall within the coastal regulations.
The petitioner, however, categorically denies that the site falls within the CRZ and submits that the place from where the business is proposed to be run is functional for quite some time.
Last 9 years.
For the last 9 years. Yes.
I have a state record.
Petitioner is not here. I'm making it not today.
Yes.
I have another statement.
Not today.
Municipality.
All right, 370, what is the matter?
Your Lordship, I am for respondent 1 to 4 is related to an illegal construction done in a prohibited area of ancient monument. So that is the case. And my formal prayer before your Lordship is that if the matter can be taken up next week.
Your prayer is?
She's praying for not today.
Not today? All right, not today. Next.
371.
I am here for the petitioner, my lord. Led by Mr. Sandeep Ghosh. My lord, the case is that petitioner made a representation before the respondent state authority for permission for option for assisted reproductive technology. IVF, my lord. That is pending for consideration.
Since when?
Since 2024, he made application August.
What is the age?
The male partner crossed the age 55 years. That is why, my lord, your petitioner made.
The lady is only 22.
Yes, my lord. Marriage solemnized on, my lord, 20.
What does the parties do?
Petitioner number 1 working as government servant.
Petition number 1?
Working as government servant, my lord.
Government servant?
Yes, my lord.
Where? What does the petition number 2 do?
Housewife. No. Petition number 2 is, my lord, government servant, and petition number 1 is housewife, my lord.
Petition number 2 is a government servant, he'll be retiring.
No, my lord.
What no?
55.
He's 55.
Yes.
If 1 year back, that means 56. He'll be retiring soon.
Age, my lord, it has been mentioned in paragraph 5, my lord, age more than 55 years. In paragraph 5, my lord.
Certificate of marriage. Page 15. Where is it?
Petitioner got married with the petitioner number 2 on 19th April 2023.
Special marriage officer.
2023.
Lord, kindly come to page number 43, my lord.
Listen, page 15, I can see a marriage certificate.
That is a
4th September 23, issued by the special marriage officer, certificate of marriage.
Marriage, my lord, in paragraph, first paragraph, my lord, as mentioned in 2023.
Yes, 23.
The
And then
petition filed in 2024.
immediately. What?
Well, kindly make it not today, my lord, because, my lord.
Next.
I have the state lordship.
The registered cooperative society, my lord.
Register of petition is not here.
No, my lord.
Not today. Does it fall within group 9? Register of cooperative societies is there. Will it fall within group 5 or not?
It's a group 5 issue.
My lord, I'm apology, my lord. It's not my 374, my lord. 374.
Yes.
374, my lord, is, my lord.
Separate.
Separate.
Anyway, not today.
My lord, 375, I'm praying for not today.
All right.
I'm appealing for the respondent.
Yes. Petition is not here, not today.
77, Lord, I am for the petition.
Who is your other side?
Appearing for the first time.
What is the matter about?
This is also regarding ART.
Airtel?
ART. ART.
ART.
The couple is aged, the husband is aged 64 and the wife is aged 59.
Both are overaged.
Both are over age.
Cannot be.
May I submit? May I submit? I know.
Looks this act.
Yes.
Kindly takes a look at the judgment. It is an interim order. The issue is pending. The Delhi High Court under similar circumstances has passed an order.
Right.
Will
Let affidavits be filed.
Kindly.
I am aware of this order.
And it is based on an order of the Millard. Kindly passes the same order so that the
No,
treatment can
sorry.
continue because Millard.
Sorry. The issue to be decided in the instant case is whether the couple, being parties to the writ petition, will be entitled to get the benefit of the assisted reproductive technology (bracket open) regulation close Act, 2021. Stop. Both the parties are for availing benefit under the Act. Stop. Paragraph. The issue in question is to be decided upon exchange of affidavits. Stop. Would you like to file an affidavit?
No, my lord, that acts itself, my lord. Not
Doesn't say so. Very well. Affidavit দেওয়ার দরকার নেই না, affidavit directionটা কেটে দিন. Let the matter be posted for hearing in the combined monthly list of November.
In the meantime, Millard, if your lordships kindly consider, because ultimately, Millard, if there is no interim order, the purpose is being frustrated. Because facts are similar to the Delhi High Court. Because
And suppose the court comes to an opinion that he will not get the benefit, then the parties will be reeling under an expectation that they may get something out of the court's order. The court is not going to allow that.
One party is less below, lordship has considered.
I have.
Yes, that's what I'm saying.
but here the fact says that the treatment
Doesn't matter.
started
376.
before.
378.
Look, 379 for the respondent number 2 registrar cooperative society.
Not today.
Lordship, I'm for the petitioner. I pray for not to give.
For the state, my lord.
Lord, I'm for the state.
Not today. Not today.
For respondent number 4, my lord. 389. 390. 91. 392.
I'm for the state, my lord.
393.
This is my affidavit of service.
Are you aware who your other side is? No? What is the matter?
No, this is only for direction upon the register, upon the respondent number 2 for act according to law, my lord. According to section 20. In fact, respondent number 2 did not take any action under section 22 of the subsection 2 and 23 of the West Bengal Societies Act. I am only seeking a direction upon the respondent number 2 to take action as per section 22(2) and 23 of the Act. Nothing else, my lord.
Did you make any request before the authority to take steps?
Yes, my lord.
Is it page 19?
Page 23.
23. Please come. The petitioner seeks consideration of the representation filed before the registrar, registrar of firms and non-trading corporation, West Bengal. Stop. A representation made by the learned advocate for the petitioner is pending consideration before the aforesaid authority. Stop. Without going into the merit of the said representation, the instant writ petition is disposed of by directing the respondent number 2 to consider and dispose of the legal representation. Are you there? All right. You have any instruction? No. To consider and dispose of the legal representation filed on behalf of the petitioner in accordance with law. At the earliest, but positively within a period of 12 weeks from the date of communication of this order. This learned advocate for the petitioner is directed to forward copy of the legal representation along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court. Legal representation date ta diye din to 8th July 24. Yes, sir. Disposed.
I am grateful, my lord.
For the statement.
Not today.
95.
My lord, I'm for the bank, my lord. The petitioner has sought for encashment of 2 certificates. That has been done, my lord. This is the compliance.
None appears on behalf of the petitioner.
That amount has been transferred in his savings account as he has sought for. 395. My lord, paragraph 3 of the writ petition that states that there's the account number, savings account number mentioned in paragraph 3 of the writ petition. And encashment of 2 certificates. The same account number will tally. Paragraph 3, my lord. Account number 139-210-100-8721. The account number is the same. And the amount has been deposited in his savings account.
None appears on behalf of the petitioner at the time of call. Stop. The petitioner has sought for encashment of 2 certificates. Top learned advocate representing the bank submits upon instruction that the certificates have duly been encashed and the amount credited in the savings account of the petitioner.
Yes, Master.
The statement of accounts of the bank dated 15th July 2025.
That has been done in December 2024 itself.
All right. Showing the credit in the petitioner's account placed in court today be retained with the record. The writ petition stands disposed.
Madam for the petitioner. This is my affidavit service.
What is the matter about?
Petitioner wanted to purchase 2 plots of land. One is recorded as house, that is agricultural land. It appears from my lord page 20. I have annexed the record of right. And my lord, second plot is my lord 1 to 3, that is pukur. my lord, I approached the registering authority for presentation of deed, my lord, wherein, my lord, I have obtained the, my lord, valuation, that is, my lord, page 20. If your lordship kindly,
Yes, then what has happened?
my lord, shown value is, my lord, 95,000. But when I have presented my deed, my lord, they have, my lord, the registering authority, without having any authority, my lord, change the nomenclature, nature and character of the, my lord, land, my lord, from house to veti. And, my lord, kindly have a look, my lord, page 33.
Yes.
My lord, shown value of plot number, my lord, 1236 with 7 decimal was 95,000, but it was abruptly changed as 4,62,000. And second, my lord, 1238 shown value was, my lord, 5,16,000. I have annexed, my lord, page 20 and 21. My lord, it was changed 7,74,000. Against that, my lord, I made a complaint representation to the page 36 to the IGR and CSR West Bengal, my lord, stating that the registering authority, without having any authority for change the nomenclature of the nomenclature of the land, because house will be treated as agricultural land.
No, where from are you getting the nomenclature?
My lord, yes, page 33.
Where from are you getting the nomenclature that it is house and it is not?
Yes, my lord. My lord, I have annexed the, my lord, the
Record of rights.
Record of rights. My
So
lord,
it is
page,
just updated.
yes, updated. My lord, when I am, my lord, going to register it, my lord, I obtain it, page 20, 1236. My lord, nature is house. House cannot be changed as VT. My lord, it is a procedure 4C of the West Bengal land universe is a very, my lord, long
No,
term
there
process.
is no conversion. Absolutely
conversion.
no conversion.
I wanted that this land is only house. My lord, the shown value that was given, my lord, 95,000 cannot be, my lord, 4,60,000. I made a complaint to the
Please come. The petitioner is aggrieved. As the petition as he cannot register his plot of land because of the illegal change of the classification of the land in question. Stop. Paragraph none represents the respondents. Stop. List the matter on 4th November. Stop. Let notice be served upon the learned advocate representing the respondents to come ready with written instruction on the adjourned date.
I will be kept with the
Yes, service is taken on record.
grateful, my lord.
97 I am for petitioner. This is the evidence.
Yes.
Petitioner is an owner of a property having leasehold right. Since it is the owner, the housing department is the owner. And the premises number which was allotted to the petitioner, which is same premises number allotted to the adjacent police station also. Page 48, 49, 50.
What is your prayer?
Yes, my lord.
What is your prayer?
Prayer, my lord, to rectify my allotment number. Otherwise, to consider, and second prayer is to consider my representation also. Page 48, 49, 50. This is a photograph, my lord. Kindly see the number.
48, 49, 50 are all photographs.
All photographs, my lord.
Where is your representation?
Representation is, my lord, page 52, my lord. And 52, 50. Kindly have a look of page 50, my lord. This is a police station premises number. The same police station.
Please come. None represents the respondents. Stop. Affidavit of service filed in court is taken on record. Stop. The petitioner alleges that the respondent authority allotted same plot number in favor of the petitioner and also in favor of the Sarsuna police station. Stop. The petitioner prayed for rectification of the error by filing a representation before the respondent number 2, which is alleged to be kept pending. Stop. Without entering into the merit of the grievance of the petitioner, comma, the instant writ petition is disposed of by directing the respondent number 2 to take into consideration the representation filed by the petitioner strictly in accordance with law and to dispose of the same by passing a reasoned order after giving reasonable opportunity of hearing to all the necessary parties at the earliest, but positively within a period of 4 months from the date of communication of this order. Stop. If the grievance of the petitioner is found to be proper, comma, then necessary remedial steps shall be taken by the authority to rectify the mistake. Stop. Next. Learned advocate for the petitioner is directed to forward a copy of the representation along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court disposal. Next.
What the response?
Not today.
400, my lord.
99 is
We
you
are
are there? 99?
Yes.
What is it?
That answer point, that I am the rightful owner of the property.
Yes. Are you there in 399?
Side by my land, PW land is there. Now let the private
399?
respondent-
399, I am for the private respondent.
All right.
and
Yes.
the private respondent.
There are so many. Who are you representing? All?
Yes, ma'am. 7 to 36.
7 to 36.
Yes.
Has Wakalatnama been filed?
No, Vokalatnama have been given but has not yet been filed, my lord. Given.
Given the writ petition was filed more than 1 year back, why are you keeping the Wakalatnama with you? This is meant to be filed in the department and not to be kept in your brief.
Yes. I shall file in course of this day.
What is your prayer?
Prayer, my lord, only one thing, my lord. Your lordship kindly see page 70.
Yes.
Prayer portion is there, first page 70.
What is your submission, private respondent?
Private respondent have not made any construction in front of the petitioner's land.
Did you make any construction over the government plot of land?
That will be decided by the assistant engineer.
Let the assistant engineer decide. Please come. The petitioner alleges that the private respondents have made unauthorized and illegal construction over government plot of land. Stop. A representation for removal of the unauthorized and illegal construction made over the public road is pending consideration with the respondent authority. Stop. Prayer has been made to direct the authority to consider the objection filed by the petitioner. Petitioners. Learned advocate representing the private respondents submits upon instruction that the construction made by the private respondents are not in front of the land of the petitioners. Stop. There is, however, no denial as to whether the construction is over public road or not. Paragraph. Upon hearing the parties, the instant writ petition is disposed of by directing the assistant engineer, respondent number 3 herein, to consider and dispose of the representation filed by the petitioners strictly in accordance with law after giving reasonable opportunity of hearing to all the necessary parties and by passing a reasoned order. At the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. Learned advocate for the petitioner is directed to forward a copy of the subject representation to the aforesaid respondent at the time of communicating the order of the court. Stop. If the grievance of the petitioner appears to be proper, comma, the necessary remedial steps shall be taken by the authority. ঠিক আছে? Are disposed. Leave granted to the learned advocate representing the private respondents to file the wakalatnama in the department in the course of the day.
By tomorrow, by tomorrow.
By tomorrow, it's already 3:15. By tomorrow.
If it is possible, otherwise by tomorrow.
By course of tomorrow. ঠিক আছে? Service is taken on record.
Yeah. Private respond.
Yes. 400.
My lord, I'm
Both of us are
petitioner.
there.
Yes.
My lord, petitioner, my lord, with a valid license running sawmill for cutting, my lord, palm wood, but with a valid license. What is happening, my lord? The PWD demand for extension of the road, my lord, the land has been, my lord, acquired, so my lord, petitioner could not run the license. Thereafter, what is happening, petitioner now since he is running, my lord, petitioner, my lord, purchased one land to other moja for shifting it. But my lord, till my lord, 2023, my lord, I could not, my lord, shift that unit. And my lord, in the middle
What
of
is your prayer?
my prayer, my lord, here, my lord, last notice, my lord, kindly see.
Kindly comes to page 24 under challenge.
24?
Under challenge, representation, page 31. Kindly see these 2 pages.
24.
Page 24, my lord. My lord, behind my back, my lord, materials were seized. No seizure list.
বাজেয়াপ্ত করা হইলো উপযুক্ত
7 দিনের মধ্যে খড়গপুর ডিভিশন অফিসে যোগাযোগ করবেন।
Yes.
My lord,
June 24.
Thereafter, first demand justice, page 25. On 24 July 2024. Thereafter, representation by the petitioner himself, 31 page. So, Lordship, it can be a case of consideration, nothing more.
My lord, behind my back, everything has been done. The machine seized, my lord.
Page 31, he says, kindly sees further reference, calling me for the solution of the dispute.
So, since it is directed by the
In
notice.
fact, we told him, you come and contact us within 7 days.
But my lord, they could not contact. So, as such, my lord, submitted the first my lawyer demand notice. Thereafter, the petitioner submitted representation. It is direct to meet with the one of Kharagpur division.
Why was it seized at the first place? Do you have any instruction? Page 24.
No, my lord. On
বাজেয়াপ্ত করা হইলো for what reason?
Behind my back, when
করা
everything.
হইলো উপযুক্ত প্রমাণ
Praman is different, but why was it seized? Any reason? Please come.
My lord, when I was absent, my
The petitioner is aggrieved by the act on the part of the respondent authority in seizing the articles, including machines, including sawmill, including the machines in the sawmill behind his back.
by the respondent of 4.
Action of the respondent বললাম তো respondent number 4 করে দিন. Behind his back. Stop. It appears from the documents annexed to the writ petition that the articles were seized by the forest range officer on 20th June 2024, and petitioner was directed to visit the office of the authority within a period of 7 days.
I went, but they could not, my lord, meet with me.
Oh, license was valid up to 2017. Kindly see page 17.
But that was stopped because of my acquire of the land by the PWD department.
The petitioner failed to contact the concerned officer within the prescribed time limit Stop. Thereafter, a detailed legal representation was filed before the authority. Which is pending consideration. Stop. Paragraph. Without entering into the merit of the grievance of the petitioner at this stage, comma, as it appears that the representation of the petitioner is pending consideration before the authority. Accordingly, the instant writ petition is disposed of by directing the Divisional Forest Officer, comma, Kharagpur Division, being the respondent number 3 herein, to consider and dispose of the petitioner's
In detail, page 25, my lord.
legal representation dated 24th July 2024 in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties and by passing a reasoned order at the earliest but positively within a period of 12 weeks from the date of communication of this order. Stop. Learned advocate for the petitioner is directed to forward a copy of the legal representation along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court.
Malu, when Malu, they will call for hearing, any
Yes.
lawyer Malu appear, they could not Malu ignore to Malu to appear before him.